Okay, good afternoon. This open meeting of the Board of Appeals is being conducted hybrid remotely to Chapter 2 of the Acts of 2023. Ensuring public access does not ensure public participation unless such participation is required by law, and this meeting will feature public comment. Please note that some attendees are participating by video conference. If you're on video conference, please be aware that other people may be able to see you, and take care not to screen share your computer. All materials that have been provided members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless the chair notes otherwise. If you're on Zoom, please join in listening mode. You can click the raise hand button if you wish to speak. Through staff, I will call on those who have raised their hands in the order they were raised. All questions should be directed through the chair. And please, on Zoom and in the room, if you wish to speak, even if you've spoken before, please approach the microphone and give your name for the minutes. Okay, please permit me to confirm that all members are present and can hear me. Elisa Allen. Here. Michael O'Mara.
Here.
John Brescher.
Here.
Joe Marklinger.
Here.
Lisa Botticelli.
Here.
Okay, great, thank you. Okay. Did you text Jim? No. No, here he is.
Okay.
I did too, wasn't in
And for the record, Jim Mondani just joined the meeting as well. Okay, so I'm going to call to order the July 11th regularly scheduled zoning board of appeals meeting.
What's that?
Would someone make a motion to approve the agenda as drafted?
So moved.
Second.
Okay, so John makes the motion and Michael seconds. I'll do, I don't have to do roll call. Okay, so if you're in favor of approving the agenda, please say aye.
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 That motion carries. Next, we move on to public comment. Public comment is for items not listed on the agenda or reasonably anticipated to be discussed today. Is there anyone on Zoom with a hand up for public comment? No. Is there anyone in the audience who had anything to discuss at public comment or present at public comment that is not reasonably anticipated to be discussed for any item on the agenda? Seeing none, we can move on. Approval of the minutes from May 9th and May 30th. I reviewed them. I didn't have any changes. Did anyone have any changes?
I thought they were fine.
Okay. Would someone make a motion to approve the minutes from May 9th and May 30th?
I'll move to
Second.
Okay, so Joe makes the motion, Elisa seconds. All those in favor of approving those minutes, please say aye.
Aye.
Okay, so now we're going to move on to the remand hearings. The first one we're going to address today is Cathy Ward, application 11-24, 9 West Dover Street, attorney Pickering-Cook presenting. Sitting for this is Susan McCarthy, John Brescher, Michael O'Mara, Elisa Allen, and Joe Marklinger. Okay, so last meeting, we heard from both sides. We heard from the public. It looks like there's more, I think there's more people here today than we had last time. Before we move on, so Nina Pickering-Cook, did you have anything that you wanted to add to your presentation from last time?
Sure, thank you. Good afternoon, Madam Chair, members of the board. Nina Pickering-Cook on behalf of Cathy Ward. I do have kind of a brief closing statement to make right before you close the hearing. So I don't know if you want to hear from more members of the public or if you just want to hear from me now. I'm happy to do that, whichever your preference is.
Why don't we see if there's anyone from the public? We'll see from the Grapes side, anyone from the public, and then
Sure.
we'll see what the board wants to do.
May I just make a comment before
Sure.
we get into it? Hi. reflecting on the last time we met on this subject, I just want to let everyone know that it was brought to my attention by some people in the community that Lisa Botticelli, when she spoke, when she was sitting on this board, literally sitting on the board, she's an alternate and she's not voting on it, but she had some comments about her Silver Street neighborhood. And I just want to be sure that if anyone has a comment that's on the board that is personal and is not representing the board and is a personal comment as a resident, about a certain neighborhood, that they should speak and define that they're speaking as a resident and not as a representative of the Zoning Board of Appeals. And I think there may have been some conflict in doing so while she was sitting at this table, giving her opinion, which she's completely allowed to do. But I think she needed to join the people in the audience and speak on the microphone as a resident and define that before commenting.
Okay. And I do know, and I believe, Lisa, you can confirm, you did file with the town.
I did. I spoke to the attorney
Let
of
me
the
just
day.
let me finish what I'm saying. The conflict form, which allows, if there's perhaps a perceived conflict, that you recognize that might be a perceived conflict, but you do not, you being whatever individual files that form, do not feel that perceived conflict impacts your ability to objectively make a decision on whatever the issue is ahead of you.
That's correct. I spoke to the attorney of the day and given my distance away from Silver Street, although I'm not on the abutters list. I live on Pine Street. I can't remember how far away I am from the site. He said that he sees no issue with me sitting as a board member on this issue. And I know I'm not a voting member of the board. And certainly, I think every member of the board voices comments and opinions, personal opinions. I mean, that's part of what we're doing. So it doesn't.
Through
I
you, Madam
apologize if
Chair.
I should have made that clear that I live on Pine Street. But and I'm perfectly happy to just sit off of this if Elisa feels that there is a conflict, I'll just step down. I don't have to make any comments.
I am not trying to keep you from saying comments at all, and you're entitled as a community member to give your opinion, but I just think you need to, with so many things, you being a previous member of the Act Now board and now being a member of the ZBA board and being a resident of that Pleasant Street, Silver Street neighborhood, I think it's just important when you do speak up on something like that to be clear which interest you're representing. Are you representing yourself as a private citizen? Are you representing yourself as a ZBA board member? Or are you representing Act Now or being a previous board member of Act Now?
Okay, so through you, Madam Chair, I was also a ZBA member when I was already on the advisory board of Act Now. I do not sit on the board of Act Now. I want to make that very clear. Never have. I sit on the board of Act Now Community Initiatives, which is a separate organization dealing only with the Lease to Locals program, not with the short-term rental advocacy, which Act Now is no longer doing, and I'm not a board member. Second of all, I think anytime I speak as a board member, I'm also speaking as a citizen and also I'm not speaking as a public abutter. I was voicing my concerns not as an abutter. I just mentioned the change in the neighborhood. I wasn't speaking as an abutter necessarily. I was just using my own experience living in town to give my opinion as a board member.
Okay.
And clearly people don't like that.
So it's up to you, Lisa. I've also had members of the community contact me about concerns about.
And I'll just step down.
Okay, if that's what you want to do, because it's up to each board member to determine their level of, for a voluntary recusal unless the parties or the applicants feel that there's a conflict and would like the board member not to sit. But if you're willing to do that, I think that would alleviate some concerns in the public.
Yeah, then I'll just sit down on both of them. So why don't I'll just exit the meeting completely.
Okay.
Okay, bye.
Will you come back for the last 3?
No, I don't think so. I'm in Vermont on vacation, so I won't.
Okay.
Okay, bye.
Okay.
Madam
Okay.
Chair, just a quick point here. I was getting text from Charles. If you're not using your microphone, turn it off. We're getting a ringing sound on YouTube.
Okay, thank you. Okay, so back to the matter at hand. I think I'm going to go to members of the public unless the Grapes Council would like to speak now. Where would you?
Yeah, I would like to speak now. If
Okay.
I'm Chair.
Okay,
Well, if I have the floor,
you do, yep.
reintroduce myself. I'm Attorney Robert McLaughlin. I represent Peter and Linda Grape, owners of the West Dover Street property. Linda is here and is with you in the audience, and Peter is on Zoom. Linda's here to answer any questions that may come up, but I don't expect that she will have anything to say. In the package that I received, there were submissions from Attorney Dan Bailey and Attorney Stephen Cohen. Let me parentheses say with Attorney Stephen Cohen, a terrible tragedy, and I pray for his speedy recovery. I'm sure I speak for us all. I want to move that those submissions that were made, that they be considered part of the Grape record. So, Your Honor, Madam Chair and members of the board, I'm not going to, and certainly try not to repeat everything I said before. You won't hear me harping on the words of subordinate, incidental, and customarily, but Attorney Cook has made a submission. It came in a few days before, and under the rules, I was unable to submit to anything in writing to respond to it. So this is my opportunity, and I do want to respond to it. And let me say, before Stella, the famous Linfield case, and Judge Vay's decision, there was only one form of single-family use. It didn't matter whether a family lived there a week, a month, or a year. It was always the same use. The famous Stella case, which is distinguishable for many reasons, which I won't go into, but it recognized a distinction between short-term rentals and long-term rentals. And of course, that's what Judge Vay seized upon, and he found short-term rentals as a new and distinct different use, and it was not specifically allowed. And that, of course, was the core of his decision. Attorney Cook has now tried to create a third type of single-family use. We have short-term rental use, we have personal long-term, and she's now trying to create something called vacant use. Being facetious, vacant use to me is an oxymoron. How can something be vacant and be used? It just makes no sense. I don't want to repeat all my other argument, but of course, succinctly, an owner owns it and has the right to use it 365 days a year. He maintains it 365 days a year. But most importantly, contrary to the Nantucket zoning bylaw, Judge Vay's decision in the case, the same Judge Vay in Mataloni versus McCarthy, and if you remember, that's the case of the shack that sat vacant for years, but could only qualify for a special permit application if it was in fact maintaining a single family use that had not been abandoned. And Judge Vay seized on the words of the Nantucket zoning bylaw that the use was used or to be used. So that it is, I think, very controlling principle on that issue of something that's vacant or not being used. It's still single family use. We all agree there must be some form of a short-term accessory use. And there's 3 points I want to make. First, I want to address directly Attorney Cook's suggestion And she suggested short-term rentals be allowed 1 day less than personal use. And she says that would be determined by reference to income tax returns and by a comparison to submissions with the Department of Revenue on short-term rentals use. It's completely unworkable. I don't know who's going to keep track of the 1,700 different days that short-term rentals are allowed. Comparing those two databases, and I won't get into so much the Department of Revenue, but I want to look at the other side of the equation, which is the use of the IRS. And let me say at the outset, people's income taxes returns are private and privileged except in extraordinary circumstances. So that I'm sure if this board adopts that method of determining how much short-term rental is accessory use, they're going to face a lawsuit from people who are refusing to turn over their income tax return. The whole purpose of the income tax return is to determine how much is deductible by the owner of the property that has rented it. And it's a very fair way of taxation. Most of the expenses, the heating, utilities, the cleaning, the landscaping, and so forth, is when the property is occupied. And so the IRS allows someone to compare that ratio of if $100 is spent and it's 70 for short-term rentals and 30 for personal expense, they can deduct the whole 70%. The owners are incentivized under that system to reduce their own personal occupancy. If one were to accept this way of determining the availability of accessory use, the same owner would be incentivized to put down the number of days, which is always 1 day more than what they rented it for that year. That's a perfectly legal thing to do. It's not tax evasion. In fact, what they're doing is they're causing themselves to lose some tax deduction. But it just absolutely accomplishes nothing. It means they pay more taxes, Uncle Sam makes more. But for all practical purposes, every tenant, every owner has a right to adjust the ratios the following April and just make sure they put down personal use as more than 1 day that they rented. It doesn't accomplish a darn thing. The second point I want to make is the point I raised on June 3rd, which is at that point, the Grapes had not rented their home for 1 day. So how many days in 2024 were they entitled to have short-term rentals? So it's always backward looking. And how many years back do you look? 1 year, many years? I mean, and what that procedure does is it establishes a cap. If there's a new purchaser or a new short-term renter, they can't have any accessory use because they didn't rent it at all last year. And they can never acquire a base. People can have life changes. Someone can be renting historically for 2 weeks a year, and now they have 2 kids in college, and they got to do it 4 weeks a year. They can never do that because they can never get ahead of what their history was or their base was. And in fact, it is extremely unfair. Someone who only used to rent for 2 weeks needs the money, lives next door to someone who's renting for 12 weeks because they used to rent some more. It's an illegal interpretation. There's no practical government purpose, and it's, in fact, unequal protection of the law. That'll be the second lawsuit if we adopt Attorney Cook's procedure. I won't address her list of horribles of mixing zoning law with residential exemptions, a right to vote, or steamship tickets. I will say, if I move into a new town, declare that as my domicile, I can register for the vote that day. But let me move on to my third point and last point, which I think is most important. I will address Judge Vay's decision and what is consistent with his decision. Attorney Cook, at the hearing, argued before Judge Vay, do not remand it, do not remand it. And this is a quote from Judge Vay's decision. She's confident that the frequency of the Grapes rental surpasses any permissible subordinate use. Judge Vay flat out rejected her argument. And that's exactly the argument she's making today. Judge Vey could have decided that. He had the grapes' personal use and their short-term rental, but he knew it's not his province to tell you how to do it. In fact, what he said was, and this is another quote from his decision, the court shouldn't supply rationales for local decisions that the local board hasn't developed itself. Judge Vey quotes the famous footnote in the Stella decision that different results, and Nantucket is not Linfield, and goes on and say maybe a different result, as well as what is considered customary accessory use in a particular community. Judge Vey did not retain jurisdiction. Simply put, Judge Vey has given this board a blank slate. It's for you to decide what is accessory use. So we are comparing short-term rentals and long-term rentals. There's no other way to compare them other than looking at how long each exists. We have to look at and compare a number of days. I think we all agree upon that. But the only conclusion is that you have to compare every day. 365 days except leap year, 366 years. And you will find that so long as someone has not rented it in excess of 182 days, then that is indeed subordinate, customary, and incidental is accessory use. So I thank you for the time, Madam Chairperson and members of the board. And I'm on the line continually to answer any questions anybody may have. And as I said earlier, Linda Grape is in the audience. Thanks again.
Okay, thank you. Is there anyone else on either side that wants to speak right now before I go to public? No, okay. Are you for public comment?
For public comment on Cathy Ward.
Okay.
Okay. Good afternoon. My name is Darlene DeMichelle, and I live at 2 Birdsong Lane, and that's in the Historic District. And I'd like to comment on the accessory use definition being considered today. I won't spend a lot of time talking about our specific situation, other than to say that our neighbor is operating a business on our private lane. His 7-bedroom private dwelling is leased to a membership club called Exclusive Resorts, and the secondary 4-bedroom home is listed by a local realtor. This summer, in an unregulated environment, we have witnessed as many as 58 guests coming and going in 1 week. I understand that this will be capped at 26 guests per week if the current article with 8 occupancy changes in July and August goes through. But my understanding is that the current proposal will also allow the chaos to continue in the shoulder months. But I am speaking today to strongly encourage you to enforce our current bylaw, which I understand allows a property owner to rent equal to or less than the time the owner lives in the house. If a license is given to a property with 2 dwellings, will this require each dwelling to have a separate requirement for owner occupation? So for example, if both houses are rented in July and August, will there be a residency requirement for 16 weeks? If it is rented in the shoulder months, will that extend the residency requirements? I have serious concerns about the proposed accessory use definitions being manipulated to suit a purpose. If the number of days when the homes are not rented are considered owner-occupied, then there will be no restrictions or STRs whatsoever, and therefore no zoning. There'll be no restrictions on STRs whatsoever, and therefore no zoning. In my opinion, considering a vacant house to be occupied is an oxymoron and defies logic. So I respectfully submit my request that you uphold the current accessory use definition and ask that you reconsider restrictions on the shoulder months so that we'll have the ability to enjoy and live in our property without the constant churn and the traffic and the disruption that takes place in our quiet Quaker neighborhood. Thank you.
Thank you. Do we have anyone else in the audience who wishes to speak?
Hi, good afternoon. My name is Dennis Murphy. I'm from Hill Law on behalf of the Nantucket Land and Water Council. I submitted a letter last week, and I heard the beginning of the meeting, so I want to be clear what my interest is here on behalf of the Land Council. The intensity of use that's allowed under any zoning regulation is directly related to the depletion of resources, including natural resources on the island. And so that's why the Land Council has an interest in this case. I heard what Attorney McLaughlin said, and I would respectfully suggest that letters from attorneys in another case might confuse things. You're here in a very specific role, a role that I served in my own town on the zoning board. This is a remand of a particular litigation based on a certain set of facts, and the facts from another case are not relevant to that. Also, the use of the property in 2024 is not relevant to your consideration, which is based on a legal record established in the case. And I think that is the critical thing. If you were here and you were a mini town meeting and you were being asked to make policy, then a lot of these things are proper considerations, policy arguments. But instead, you're being asked to make very specific adjudicative decisions based on established record. And I wanted to, I'm not going to steal my sister's thunder. Attorney Pickering-Cook will have her summation, but I did want to make it clear that the things that are concern of the Land and Water Council are the following. First of all, the judge has established that STR is not allowed as a principal use in the residential district. He didn't do that in abstract. He did it based on the facts of this case, the exact same facts that you're being asked to look at a separate legal question about whether it might be allowed as an accessory use. Now, the judge didn't reach that question because he deferred to you, that you ought to be able to address it in the first instance, which I think is the right answer for a judge. They sit in judicial review of what a board does. You're the initial body that adjudicates the meaning of a zoning bylaw. So I don't have to remind you, the two things that he read in your own zoning bylaw that were important are as follows. The reason that he reached the result he did, that STR is not allowed as a principal use, is because that use is not specified in your bylaw. And there's a provision that says uses not expressly permitted are forbidden, they're prohibited. STR, those words and that term doesn't appear anywhere in the bylaw today. And uses that are customarily incidental and subordinate could be accessory. I've been a zoning lawyer for over 20 years. You could redraft the bylaw and you could put STR in there explicitly. There's been several articles that suggest just that. You could put it in as an accessory use. It could be an expressly permitted accessory use. It's not in there right now under primary, principal or accessory. And so the consideration is limited to, based on this record, is the Grape's use of their property for the 5-year period of time that is at issue in the record. Was that customarily incidental and subordinate? So these are the facts and I've laid this out in my letter as I understand them. First of all, it's undisputed that they bought the property as their third home for the purpose of renting it. That was their purpose, their primary purpose. Second, their actual use during the period in question was twice as much STR as it was for their own time on the island. Now, speaking on behalf of the Land and Water Council, that's important because from a resource consumption point of view, that is not accessory. If you're using it twice as often for one use as you are for another, then that's the principal use. The last thing I wanted to make clear is that you heard some argument about other regulations. You're not the IRS, you're not the steamship authority, you don't issue scallop licenses. But as I understand the argument, what you're being asked to do, if you count vacant days as if they're occupied, would be contrary to all those other disparate regulations and interpretations that other agencies and other town boards have adopted. And I would suggest that your interpretation of your own bylaw should be consistent with how similar provisions have been interpreted elsewhere in town. Thank you very much.
Yes, Elisa, you have a question?
Attorney, I'm sorry, I didn't get your last name. Murphy, yes. I have a question for you. You said you just said you know that the Grape's sole purpose of purchasing this Nantucket property was to use it as a rental. How do you know that?
Oh, it's not that know, that's Judge Vay's finding.
But you just said you know the Grapes bought this property for the sole use of renting it. You just said that you know.
Oh, I'm sorry if I misspoke. I
Okay.
don't know the Grapes. I've read the case.
So were you quoting the judge in the case? He said, I know the Grapes bought this property for the sole reason of renting it?
Yes. So it's the decision, page 6, paragraph 6. The Grapes purchased their property, quote, in part because of its rental potential.
In part, not the sole purpose.
Yes, and I didn't mean to suggest that was the sole purpose.
That is what you suggested.
Okay, let me correct what I said.
And Mrs. Grape is here. We could just ask her.
Okay.
Okay. Before I don't want to get into a back and forth, but I think we can all look at paragraph 6, and Mrs. Grape, I'll give you the opportunity to respond to that, but it does say that while the Grapes don't rent their Wellesley or Florida properties, they bought the Grape property in part because of its rental potential.
In part, not as a sole
Okay,
purpose.
so
Okay,
that's-
got it.
If I could clarify, and I'm reading from the bottom page of my letter, the thing that I think is not disputed, and the court did find explicitly, is that the property is not their primary residence. So my apologies for misspeaking. That I don't think is disputed in part or otherwise. Those
Which
lines are-
is, okay, thank you.
Yeah, thank you.
Okay. Mrs. Grape, do you want to respond?
Thank you. I don't know if this is on.
I think it is.
Okay, sir, I'd like you to apologize. No, we're not going to get into. All right, because we bought that home, at the last meeting when we all met on June 3rd, I spoke and shared the long history that our family has had, 40-plus years of coming to Nantucket. We have been a goal of our family to have a home here. As we've said, as we've demonstrated, as we've documented, with retirement approaching, we're using the home more, we're renting it less. You can look at our statistics for this year, that is the case. But in no way was this the sole purpose that we bought our home. In fact, we enjoy much pleasure there throughout the 4 seasons, 12 months out of the year. And I will also point out that our home has a guest house, which we do not rent. And trying to be environmentally responsible when we are here, it's just my husband and I, we will preferentially use the guest house so as to minimize burden on energy. Thank you.
Okay, thank you for the clarification. Okay. Is there anyone else in the audience who wants to speak, or anyone on Zoom before I go to, okay, so Attorney Pickering-Cook, you can give your.
I'll
clo-
just sum up
Sure.
briefly. You've heard quite a bit from me, quite a bit from opposing counsel, and quite a bit from the public. First of all, I would say to Mrs. Grape, if they are in fact at this point using the home and the property more than they're renting it, then there's no problem here. Then that is accessory use, and that would be a great result. But you've heard from all of these different groups. You've heard from the lawyers give you different descriptions of what the decisions have said and what the bylaw means. Now is your turn to decide, and we really need a decision. All you're being asked to decide is whether the Grapes' use of their rental more than 70% of the time, as found by the judge, is an accessory use under your bylaw. Now, you have that definition in front of you. It's in the bylaw. You are being asked to interpret that definition with respect to the facts in this case. Again, this is different. I think you will hear from Mr. Bailey and folks next on the quick case. This is a different posture than the quick case. You're not trying to determine how often the Grapes are at their property. You're not trying to determine how often they rent their property. That's already been found by the court, right? We've already gone through that process, and you're bound by the facts that are found by the court here. So he found that the Grapes use the property as a short-term rental more than 70% of the time on average. And to meet the definition of an accessory use, the use must be less than the primary use of the property. There's no dispute in that. In fact, the court cases cited by Mr. McLaughlin and Mr. Bailey, if Mr. McLaughlin wants to refer to that, use the quote, the accessory use has to be, quote, minor in significance as compared to the other use. Page 6, paragraph 8 of the Grape decision, you have the court telling you, quote, the Grapes have rented the main house more than they've used it, close quote. It's real simple. That's your answer. They rent it more than they use it. Therefore, it cannot be accessory. It cannot be minor in significance as compared to their personal use. Now, I have to admit that there's a little bit of deja vu going on here. 2 years ago, I stood before you and I told you that this bylaw did not allow short-term rentals as a primary use in a residential district. Mr. McLaughlin told you otherwise. He said that it was traditional to rent on Nantucket, so you all should allow it. Town council told you that the court would defer to you as a local board, interpreting your own bylaw and would support your finding. Now, you listened to Mr. McLaughlin and town council. After 2 years of expensive litigation, the judge found that they were both wrong. I am asking you now, I'm imploring you now to put this case to an end by finding that the Grapes' past use, again, we're talking about the past use, the Grapes' past use is too much to qualify as an accessory use and direct any future rentals that they have at their property to be for less time than the home is used by them personally. I think we can all agree that folks don't want to spend a lot more time and money and lawyers litigating this case. Any finding otherwise is just going to lead to that vicious cycle all over again. I'm happy to answer any questions the board may have. Thank you.
You have the floor, George.
Chair. Good afternoon, Madam Chair, members of the board. I'm George Pucci from Town Council's office. I just wanted to correct one thing. Town Council was not part of your proceedings when you heard the original ward enforcement request. That was heard by the board, and then a decision was issued. We defended your decision in land court. So I just wanted to clarify that for you.
Can I ask you one more question? In paragraph 8, and maybe it's in one of the other findings that I didn't, or the finding of facts that I didn't highlight, but when it says the Grapes rented the main house more than they've used it for personal stays, so are we charged with just the main house? Are we now differentiating between the main and the guest, or are we looking at the whole property? Because my reading of this and my understanding, it's a second home, so by definition, it's not going to be, occupied 365 days a year. But are we still able to determine how to count the days of use, or is that determined? Because my reading is that we were still open to make that determination of, and I know, Madelon is a different case, but the ability of them to come and stay in their house, if they get up on a random Tuesday and they're able to come down and stay, that to me is available, and it's their prerogative of when they decide they want to eat dinner in their Nantucket house or in their guest house or garage apartment or whatever it may be versus in their home in Wellesley. So is that
That would be something relevant for you to deliberate on.
okay?
May I tag on to that?
Hold on.
Hold on.
Elisa first, then and then we'll go back to attorney.
And this is, I'm just trailing along on what Susan just said, because I recall they said they stay in their guest house even when their main house is rented. So how do we count those days? Because they're on the property, but they have their house rented and they don't rent their guest house, but they stay there even when it's rented. So,
Or even when it's not rented,
or even when
seems
it's
like,
not
right.
rented, but how do you count that?
Are we figuring that out?
You're figuring it out.
Okay.
Hold on a minute, if you would. They're asking me a question. The only thing you're bound by in terms of number of days is what Judge Vey found in the findings. So, as you pointed out, Elisa, the facts that you're bound by are set forth. They start on page 5 of Judge Vey's decision. So if he said they were there 54 days on these years, you're bound by that. The meaning of it is for you to decide, and he didn't apply any type of bright line rule either way, because you could kind of take it, you could take the argument on either side to a illogical conclusion, because if you said, well, they don't, depending on why it's vacant and how it's used, like say a property, which isn't the case here, is vacant all the time, but for the time that it's used as a short-term rental. So say you use it, they rent it, they make a ton of money in the summer season. Otherwise, it's an investment property and the property otherwise sits vacant. That would be a factually different type of case where you'd be looking at the number of days. Well, wait a minute, this is not occupied at all by the owner. It's used only for short-term rentals. And then even if you compare 90 days versus 365 days, it doesn't look significant, but that would be the type of factual analysis that you'd look at and you'd say, this isn't customarily incidental to the use. This is just purchased strictly to rent during the summer season. It's not occupied at all. So I'm not telling you how to interpret this issue of vacant days or days available to the owner versus a short-term rental, but I'm just cautioning that, there are a number of ways of looking at it, and each case is really factually specific. How, what the intent was when it was purchased, how it is used by the owner, the manner in which they rent the property, all of those. And I don't agree with any type of bright line number of days analysis, both vacant, occupied by the owner, or occupied by a short-term renter. I think you have to look at it on a case-by-case basis factually how this property is used.
Thank you.
Okay.
Two quick responses. I agree with George in that you're not being asked to figure out how to calculate these days at all. So I want to clarify that. Again, we're talking about past use that has already been determined by the court. And those calculations have already been made, including the number of days they stay at the main house versus the garage dwelling itself. So that's not something you guys need to wrestle with. Those numbers are in front of you. What I would say with respect to the main house issue is the judge, again, these are not issues that are coming up for the first time. The judge did go into all of this in his decision. The main house is the principal use of the property. So while the Grapes certainly have used the secondary dwelling at the garage more than I think they've used the main house, legally speaking, for zoning purposes, it's the principal use of the property that's relevant, and the judge has determined that to be the use of the main house. So that's why, Ms. Allen, when you're looking at the numbers, he focuses in on the main house use.
Madam Chair?
Well, while I'm standing here, whoop. Yeah,
Hold-
let me just. let
hold
me
on,
just make
Attorney
one
McLaughlin.
Clarification, Bob. While I'm standing here, you may already be aware of this. You've looked at the decision. You have quite a lengthy packet. I just wanted to clarify for you, the facts that Judge Vate sets forth, you're bound by those for the years in question. You're not bound only by that, however. You're not allowed to hear new evidence to contradict what he has set out. So those are facts that are part of your record. But he clearly also contemplated that you would hear other evidence, including from the realtors. You heard from Ms. Dye. He specifically addressed that in a footnote that he wasn't going to consider that material on this issue of principal use, but that may well be relevant on the issue of what's considered a customary accessory use in a particular community. So you've had a lot of lawyer letters and a lot of submissions, but really Judge Vade's instructions are really pretty precise. He gives you a set of facts that you're bound by. You're free to accept additional facts that don't contradict those facts, but add to the record on this issue of accessory use. And then you're to determine the meaning of your bylaw, whether it's an accessory use, one that is subordinate and customarily incidental to a permitted use on the same lot. And it's, very narrow what you're looking at but it's going to be for you to make a determination interpreting your bylaw of whether the Grapes' use of the property is the way that they're renting the property is subordinate and customarily incidental to a permitted use in light of customary practices on Nantucket. So hopefully that helps a little bit.
And if we close the hearing to deliberate, we still have you as our counsel that we can ask questions?
Correct.
Okay, that's what I thought. I just want to confirm. And Attorney McLaughlin, you had something
Yes,
to add?
just two very brief points. First of all, Attorney Cook just created a new zoning concept. Zoning applies to each lot. Now she's trying to say half of it has one set of rules and half of it has another set of rules. But the key point I want to make, which is Judge Vade's decision, Judge Vade found those numbers to determine that the property was not being used for family use. It was being used for short-term rental use, and therefore there was no right to use it for short-term family use because that's not permitted in the bylaw. When it comes to accessory use, and that's what's before you now, as I said earlier, Attorney Cook argued that he had before him the facts to make a decision on accessory use, and he rejected her argument. And he said, it should be developed, and developed is an interesting word. It should be developed by you. What is an accessory use? So then we come to how do you do it? And it's greatly complicated and impossible unless you do it except comparing days. Thank you very much.
Sorry, you can just come to the microphone and,
Hi, Edward Sanford. I've got I wrote something, but I don't feel a need to read it. Can I submit it as part of the file?
Yeah, you can submit it. Do you already have
I'm
it?
saving you 10 or 15 minutes.
Okay,
Letter?
okay,
Thank you.
okay.
Still taking public comment?
I am.
My name is Ann Duez. I live at 5 Mill Street. This appears to be boiling down to a simple question of whether or not vacant days will be counted as owner use. I disagree with that. You'll make your own finding, but I would like to highlight what I find to be a red herring in some of the arguments that have been made about, well, you shouldn't have to count days. We have to have vacant days because it's too hard to count days. That's not true. Lots of people have to count days for lots of different reasons. People who come in and out of the United States and have to limit their stay. There's all sorts of software that's available to do that. So I think to argue against keeping track of days because it's too hard is a total red herring that you should completely ignore. And with respect to the actual use of the owners, it's so fundamental to what's going on that if someone lives in a house and they rent it sometimes, or if they live in a house a little bit and rent it a lot, that clearly that rental use is more than the accessory use, which has to be incidental. So I would urge you to ignore the worries about counting days. Look, in Nantucket, we rely on people to be honest. This is perhaps misguided, but for the most part, I think most people follow the rules. We also rely on citizens to keep track of what their neighbors are doing because we don't have the resources or the people or the ability to hire people to keep track of that. And that's always going to be the case, whether you're talking about somebody speeding, somebody renting too much, or whatever. So we have to live with the situation we have on Nantucket. And to go down the line, the road of vacant days, which to me is incomprehensible, I think I would urge you to think very, very carefully about that. Thank you very much.
Okay, thank you. Is there anyone else in the audience that wishes to speak? Seeing none. Okay, is there anyone else on Zoom? No. Okay. Seeing that there's no one else with their hand raised to speak, does the board have any questions for the attorneys or the applicant? You have one, Michael?
I have one for Mr. Murphy. You covered a lot of territory.
Is your mic on?
You covered a lot of territory in your presentation, and I am a fan of the Land and Water Council. By and large, I think they do a great job. What was your main concern, though? You covered a lot of them. Was it water?
Yes, sir. So we haven't specifically quantified the resource consumption on any particular property or this one, but there have been studies that show that with greater turnover, there's use of water, transportation, all kinds of natural resources. And so that's why the interest in the case. I didn't mean to suggest that's a basis for your decision. So the reason that we filed a letter and that I'm here today is to make the point that one way to limit the intensity of use of STR on Nantucket is to restrict it to accessory uses only. And how you define that will have grave complications or ramifications for the entire environment. And that's why it's of concern to the Land and Water Council.
Thank you. Presumably that if there were restrictions on how many weeks or days they could rent, it would still be occupied by someone else.
Yes, so I subscribe to, I'm a lawyer. I take an oath, and I am accustomed to following a judge's orders. In my view, the judge has made a finding in this particular case after a trial. I do many trials, that the use by the Grapes was principally STR and not their own occupancy, their own use. That finding is made and established. And under the rubric of you're sitting in remand, bound by that finding, my argument is the only determination you could make is that that level of use has to be considered not an accessory use under the provision of the bylaw that requires it to be subordinate, because the judge has already determined in his factual findings that it wasn't subordinate.
Thank you.
Thank you.
Hold on. I don't think that's exactly what the judge found, but I think what he said was that the primary dwelling or the principal use does not allow STRs as a primary use in a principal dwelling, but he didn't make that determination. He gave us the back door of saying, but it might be accessory. An accessory might be allowed, but that's for you guys to figure out on your local situation. So I think that's actually what we're here to talk about. And then, so we'll hear one more, and then we're gonna see if we want to close the public hearing and start deliberating.
Comment on.
Oh, yeah, sorry.
Two things.
All right, hold on, let me just go to Elisa.
Sorry, I
then,
just
if
want to
you-
address two things. The lady in the pink, I'm sorry, I don't remember your name, but
Duaz.
you just spoke. You said that it is the responsibility of neighbors basically to police their neighbors in the community, and I disagree with that. I don't want to live in a community where we are tattletaling and reporting our neighbors for these types of things. It's none of our business in that way, that it's not our responsibility to keep an eye on what everybody else is doing. That's number one. Number two, another gray area in this occupancy is, what if it's not the actual people that own the house on the deed? And what if it's not people that are renting and paying rent? But what if it's a relative? What if it's the owner's best friend that wants to come here after her husband passed away and spend a month or 2 weeks or a week? Or what if it's a cousin or a grandchild with his family? That is a huge gray area on Nantucket for how we're defining accessory use and primary use on Nantucket.
I agree, so we can talk about all that in deliberation, so, because it's not clear.
That's a gray area, yeah.
Okay, so
you.
we'll hear one more public comment. I see Mrs. Grape has her hand up. Oh, okay, sorry. So, okay, so woman who's at the microphone, and then Mrs. Grape, and then this gentleman over here, and then we'll see where we are.
This is real brief.
Okay.
Patsy Wright, and this is not a hypothetical. We used to rent our house, and our water bill tripled. That's it.
Also briefly, I just want to clarify one thing. I neglected to say it prior, is if one were to look at our total all-in family use of our property, both units, it's consistently in the now 7 years that we've owned this house, it's greater than 50%. We've been on the property than a tenant. Thank you.
Not clear.
If you can just identify yourself for the,
Certainly. My name's Jeff Drazen. I live at 41 Low Beach Road. I'm just calling to make a distinction between a short-term rental, which is something that you do for profit, versus inviting your friends or family. For example, I've lent my house to people who just had one of their children die, and they needed to go away to someplace peaceful. And the environment that they create while they mourn is different than when 10 people show up in a house to party. And so I think that it's fairly clear the distinction between a rental, which is done for profit, and the use of a property for family or extended personal reasons.
Okay, thank you. So seeing no other hands, and I think the board has satisfied their questions. Okay, one more. Go ahead.
I just have an observation. If we had enforced the bylaw, we wouldn't be here right now. This is our problem. And because of manipulation, of definitions, perhaps to serve a purpose of a certain element of the community, we are sitting here because a call wasn't returned. There wasn't an action taken by somebody in a position of authority to suggest that people modify their behavior, tone it down, whatever. And that has caused a tremendous amount of difficulty, stress, caused a great deal of wasted resources. The other thing I'd like to say is that I own a short-term rental in Maine, and I just got back yesterday from having been up there trying to get the place sorted out. It is not difficult to keep track of the days when you are in your house, you're getting it ready. You have receipts, you have photographs on your phone of what you're doing, weeding, whatever the hell it is. But it is not that difficult to keep track of the days that you are either working on your home, which are exempt, or when you are actually there. That's all I want to say. Thank you.
So at this point, does someone on the board want to make the motion to close the public hearing?
Sure, I'll make a motion to close the public hearing.
Okay, so John Brescher makes the motion to close the public hearing. Michael O'Meara has seconded that. We're going to go with the 5 sitting members, starting with Elisa over to Joe. All those in favor of closing the public hearing, say aye.
Aye.
Aye. Okay, so the public hearing portion is closed, and we can enter deliberation. Does anybody would it be helpful to have from Attorney Pucci just restatement of what we are deliberating? What are the narrow question before us?
I try to speak as little as possible. But when I was standing before, I did want to cover that. It's very limited. It's on pages 23 to 24 of Judge Vay's decision.
Oh, sorry.
Under section 139-2 and 15 of the bylaw, and quote, accessory use, close quote, is one that is, quote, subordinate and customarily incidental to, close quote, a permitted use on the same lot. Then he distinguished the Stiller case that Attorney McLaughlin referred to, and he pointed out the distinction in Stiller that a different result than what happened in Stiller, which was that there was zoning enforcement involved, may obtain in other circumstances, depending upon, for example, the specifics of the zoning bylaw of the city or town, including what types of additional uses are permitted, if any. And then a big one in this case, because you've heard a lot of evidence on it, as well as what is considered a customary accessory use in a particular community. So in addition to those facts that Judge Vay gave you that you're bound by, you're free to accept other facts, as long as you're not trying to contradict the facts that are a part of the record. This issue about days that the grapes are there, not there, vacant, used by a short-term renter, is for you to decide the relevance of that within the context of this question, whether the short-term rental of that primary residence is subordinate and customarily incidental to the primary use in your community on Nantucket. So it's for you to interpret the accessory use provision of your bylaw based on the facts that have been presented to you. And anything that you determine to be of relevance, if you're questioning on it, you can certainly ask me. But again, a zoning board is entitled to deference with regard to its interpretation of the language of its own bylaw. So you're not here to amend the bylaw or clarify it or impose rules that apply generally across the island. You're just here to interpret the accessory use provision of your bylaw per the specific facts of each case that has been presented to you. And hopefully, again, that clarifies it. And, you know, some of this you don't have to interpret at all. The judge's decision speaks for itself, and you can certainly look at his language. Never mind what I'm saying or other attorneys or people. Read what the judge said. It's very clear right in that decision what you're doing here. So to the extent it's not clear, I'm here to answer any further questions that you might have.
Okay, George, thank you. Okay, where do we want to start? Do we want to start talking about the subordinate?
No, you're first.
Sorry, the subordinate, the customary, the incidental. Do you want to talk about, how do you want to?
I actually was wondering, so is the plan that we're going to deliberate and then we're going to ask for perhaps a draft decision?
I think,
that-
my thought was that we would start deliberating,
Okay.
see if we can get some of this out of the way, and then I think it's almost 2:15. We have to be out of here. The other Concom's in here at 4, maybe 4:30.
They're in here at 5, so we
But-
gotta be out by 4:30.
Oh, they are in. I thought, okay, all right, so that was resolved. Okay,
Yes.
great.
How many applications are we hearing today?
5?
5, okay.
All right.
So it's pretty, I mean,
I know.
we've been on this for a while, so.
Right.
So we could close public hearing. We could say we reflect on pages 23 and 24 of the judge's decision based on what we've heard today and come back ready to deliberate. I mean, I'd like to get through a lot of the quick one too.
Why don't we see where we are?
Well, I think that's what we're doing right now because it's 2:15. We have 15 Delaney Road. We have the 10 Main Street and 1 Gully, and then 126 Rear Main, and maybe one other one.
Yeah, one more in Madaket.
Oh, yeah, right. Okay, so.
And we're voting today?
No, we don't have to vote. We don't have to vote today on this. I mean,
Okay. Do we want to vote today?
I don't think we'll get through our agenda if that's what we want to do, so
I think before we vote, I think I'd like to see a draft decision, frankly. I mean, I think we should get a sort of sense of where we are. Hopefully we can do that today and then see.
Okay, so why don't we go?
Ideally, I think that's a smart idea.
Why don't we see where we are at 2:30 and then 2:35, 2:45? That's not going to leave us much time for anything.
I don't have a lot of talking to do. but
Okay, good.
I don't either.
I mean,
I've said
okay,
it.
why don't you start, Joe, then?
I'll start. I mean, I don't think as it's presented, in this particular case, with how the law has been explained, that what's going on now is subordinate or customarily incidental. I don't think it meets that standard. I'm done. That's what I think.
Okay.
I'm grappling with the number, with usage when you're not physically there. I guess that's about defining, you know, I understand the customarily and incidental aspect of it and the accessory use aspect, but it's the interesting one of how to define and sort of categorize the principal use as it relates to who sort of counting days or not counting days. And I'm grappling with how to articulately define that without unintended consequences.
Okay.
I wish that the town meeting was next week. And, I also wish that the scrivener of the zoning bylaw, 1972 or whenever it was, mentioned something about this, but they didn't, unless it was a scrivener's error or a scrivener's oversight, which nobody will know the answer to that. But as of today, I think that short-term rentals are a customary and allowed residential use of dwellings, and that the use is subordinate and incidental.
Elisa, do you have any comment?
I don't think what the Grapes have done as far as staying there, not staying there, their intention is anything out of the ordinary for Nantucket. And historically, what Nantucket means to a lot of people and how they're able to afford to have a house here. And I do have a hard time with figuring out, determining, how many days you're physically at the house when it's vacant versus when it's rented. And I also, we're treating the idea of renting your house for a short period of time like it's some criminal act. And it's not. It is a way that so many people, year-round people, summer residents, summer people, natives, all different property owners on Nantucket are able to survive and stay here. A lot of the middle class on Nantucket is able to stay here and survive here because of the ability to rent out the houses they've inherited, or they're able to buy a house because the expenses are offset by having that rental income. And we're acting like, it's a shameful thing to do, to rent your house out. And maybe you just want the extra money so you can go to Italy in the winter. I don't know. It's none of our business. It's a free country. And I think what the Grapes have done has been totally in line with the intention of the idea of short-term rentals and enjoying Nantucket themselves. I don't think they've done anything sneaky or criminal or out of line. Thank you.
Madam Chair?
Hold on. Jim, do you have any comment? Yeah. Yes, please.
I don't think there's a question on the customary piece. That, to me, this use is customary with what Nantucket has allowed. We call them STRs. That's a new term. Of course, STRs isn't written into our language, certainly not in 1972. We just called it rentals. And probably the whaling community called it rentals. I don't know. But, this STR thing is being misused. It's turned into a pejorative term, but it's really just rentals. That's all it is. And in terms of subordinate use, I'm like John. I would look at it, I look at it as, what is the time frame? And to me, the board I know Madelon wasn't, it was a different set of circumstances, but in that case, that person did not occupy the property at all, did not enter the property at all, and ruled that it was, for all intents and purposes, a primary dwelling, even though they weren't there. So if you were to apply that here, you got to look at the whole year. And all of us live here on island. So to me, 365 days is the measurement, not the summer. I know to a lot of people it's the summer. So we can't just look at this and say, how many days did they rent it during the summer? I think you got to look at it and say, whether they occupy it or not, you got to use 365 days. in the analysis. And that's why I asked the question in the last meeting. You know, if they didn't occupy the property, but they rented it out one day, what do you call that? Is that 100% rental? I don't think so. And I think that's 1/365th, and to me, that's subordinate. So, 2 cents.
Okay. Yep, I know. So, all right, Joe, back to you.
Well, I thought what we were doing was this specific case, these specific things that are in front of us, as I understand them. Not everybody on the island, what I used to do, what, was customary in the whaling days. It's what happened here. And I think, based on that it's not subordinate, it's not customarily incidental.
Okay.
And I'd like to say to that, through you, Madam Chair, that it is, to me, very clear that it's about intentions, and this isn't some corporate-owned property where they're churning them out. It's a private person, private family that's owning it. Like, I would love, if anybody has the statistics on this, but how many of the homes on Nantucket get rented on a short-term basis? And I think that was the intention here. And I think it is in line with what so many other property owners do on Nantucket. And I don't think their case is out of line at all.
Madam Chair.
Okay.
Can I just have
Yeah.
a couple comments?
Okay. Jim, and then we'll go back to Joe.
I think it's almost impossible to look at this without looking at it from a policy standpoint. I think, my opinion is the judge kind of put us in a bad position, because I think either the town votes to amend the bylaws or the judge makes the law. So it's hard not to look at the policy reasons for this. I mean, it's next to impossible.
Well, I think.
But if you were
sorry,
to look at it, I'm just saying that their use of the property is customary. And it's not unique, and it's not wrong. I also, when I look at the specific facts, none of what Ms. Ward is saying has to do with any of this. It has to do with noise. It has to do with people talking. It has to do with people slamming a grill top. And based on those facts, specific facts, I don't think this has anything to do with ruling against it.
It's a fair point. So Joe, did you have something else to add? And then I wanted to go back to what John said.
Say the same thing over again. I think we should be specific to this particular case.
Well, and I think you voiced how yours.
Other than that,
Okay,
I'm
so
done with talking.
okay, so
Thanks.
you have made it clear you do not think that this is, as it's presented with this specific facts, is accessory, and you don't think it meets the standard, so that's clear. All right, John, you're talking about grappling with days and how you count. I look back to this same judge talking about our zoning code and how we talk about what is a primary residence and what it means to own a primary residence. And Judge Vey, in that Madelone case that he remanded back to us for a portion of it, determined that used or to be used, it continues the structure as a primary residence. I also come down on its 365 days, and it is the availability of the home to the owner to use. There are so many different ways that people use their properties, in Nantucket, but in any vacation destination. I think that we need to be careful about, there's people who claim residency in a different state or whatever, those people have to maintain certain dates, right, to be able to claim the residency for whatever benefit they want. I really do not like the idea of us whether it's the zoning board or the town in general, trying to police who's in their house for how many days and what that means and what privileges and rights you may have on a local basis. I think that's problematic and going to cause problems. And there are some organizations on island who try to do that for, you know, the covenant program or deed restrictions, and the occupancy part is a problem. And how you calculate that, how you require people to prove that, all of it. So I don't think that the general population should go down that road. I tend to agree with John and Elisa and Michael and Jim that this is a customary use. I personally think it's accessory. I think that the grapes have demonstrated with the facts accepted, findings of facts by Judge Vey, and from the personal testimony that we've heard, and that this is an accessory use of their property in the ROH district. And I think it's incidental to the overarching primary use, which is a home away from home or secondary home for their family and or extended family or guests, or however they wish to use it when they're not renting it. So it's 25 past 2. You want to see a draft decision before we vote, you're saying?
I think that's a good idea personally, but, you know.
And so you want a draft decision from?
I think from George.
Yeah, I think George.
Lucky George.
Yeah, I agree.
George doesn't seem like he's
I
feeling
don't
too
think George is
lucky about
excited as I
that.
am.
I always maintain the same demeanor.
Jumping for joy, I'm sure.
I mean, I don't think we need to wait. I would assume that, well, we could certainly do it as a special meeting, so we're not waiting till August. But
Yeah.
it's-
I mean, it seems from the comments we've just heard that we know where we're going on this.
I'm just one opinion. I mean, if
No, but
you all think that we should-
I think
agree with John.
What?
I agree with John.
Yeah, I think from the notes that I just took, it seems like we're all, Joe is of the of a different opinion than the majority of the people up here, but which is fine, which is why we have a board to make decisions and not just one person. But I think the details are what we need to work out.
Could
So.
we do it on the 17th? Don't we have a meeting on the 17th?
Well, we have to see what happens with all 3 of the applications
Yeah,
on
I
the
know.
17th are Cohen, so we'll see.
I mean, I'd still
what
be willing to
happens.
come on the 17th specifically for this.
Yeah, I don't
I
know
think
that
it's
George
that
could turn something
important
around that
and
quickly,
not-
and Michael's not here. But I guess my question to you, George, is how specific
It's 5
do
days.
we need to be in our findings for Judge Vey to feel like, because when I was reading his decision, he was saying, and I mentioned this, that, when he was saying that when we made the original decision, and again, we were dealing with an appeal from a building commissioner's decision, so I feel like our decision-making process is a little bit different when we're deferring to the judgment of the building commissioner, when we're.
Right, remember the main thrust, and again, you did this on your own, not that I'm saying you did anything wrong in the original
Right.
decision, but it wasn't like this, that you had town council and you had all these other.
Yeah, no, but I
public
mean,
input, but
when Judge Vey said, that we didn't talk about Styler, we didn't talk
He
about.
wasn't being critical of you, because the main thrust of your prior decision was you didn't want to make policy for the island.
Right.
That was it. And so that's not your traditional zoning decision where you make a bunch of factual findings and then you apply something to that.
Right.
You thought at the time that the current state of everything was that you agreed with the building commissioner, and you were not going to set policy for the island, that you saw it as something that should go to a town meeting in terms of possible amendments. That was why your decision was fairly light in terms of findings and what you based that on in terms of an interpretation of the bylaw. This proceeding you've done entirely differently. You're not setting policy, but you are recognizing that some of the factual issues do sort of blend into policy, because if you're talking about what's a customary use on Nantucket, you are looking at a little bit as a policy matter, that's aside from.
But I mean, do we need to define for the decision, like what are the reasons that we say it's
Right.
customary? And we can pull those from the supporting.
Yeah, depending on scheduling, I'm happy, I'm flattered that you asked me to draft the decision for you to deliberate on. I'm happy to do that. I would like to work with staff in preparing that, as you normally do. And based on the record and the minutes and the evidence that's come in, the consensus that you've discussed today, without going ahead and voting, I feel comfortable that we can draft a decision which, meets the concerns of what you want to have included in that decision, including findings and, an analysis of why you're ruling the way you are, and then deliberate on it and decide if you've changed your mind or you want to go forward with that decision in the draft as the consensus has been conveyed today, or you might have some revisions on it that, then you could vote it subject to the revisions that you discuss at that meeting. But I think you've done a thorough hearing. I feel comfortable as long as I'm working with staff and preparing that draft for your consideration. It would just be a matter of scheduling. One thing I would recommend, not to make my life miserable to add to short deadlines, but I would try to do it sooner rather than later while these issues are fresh in your mind.
Does he think George, do you think the 17th, or Madam Chair, is the 17th, like in 5 days? Is that doable?
Well, Michael won't be here.
Can he vote based on, even if he's not in person?
I don't think I can even
Yeah.
zoom in.
Okay. I would even be willing to call another meeting to do so when it's convenient for everybody, instead of waiting until the August meeting. Yeah.
Madam Chair, I just want to weigh in on this. It's just not as simple as picking a day. We need to continue to a date certain. In order to get this room, I need to verify this with about 5 different staff members in the town, and I don't have that verification right now.
So let's continue to the August meeting, and then if we can make it work to do it earlier, then we will. But I think the only date certain we can continue to right now is the August.
Would be August 15th. I just was looking back through my email because when I went to try and find the available time slot for next week's meeting, I had looked into additional weeks. This room is a little more difficult. I was getting a lot back for the training room upstairs, which is not set up for a public meeting by any means.
In terms of the parameters the court has set up, you've acted with due diligence and speed on this. I'm comfortable with August 15th and reporting that to the court. I would be even more comfortable about that is if you could complete the quick hearing today, possibly, because, they involve a lot of the same issues, at least in terms of like the customary practice on the island.
Okay, so why don't we vote to continue, or someone make a motion then to continue this to the regular monthly meeting, August 15th.
I'll make that motion.
All right, so John makes the motion, Elisa seconds. Okay, so again, Elisa all those in favor of continuing to the August 15th meeting, please say aye.
Aye.
Aye. Okay. Okay, so thank you. We can take a 5-minute break. I was just going to say thank you, everyone who came for that hearing. All right, let's get back to it. Okay. We're going to move on now to, all right, ready, guys? All right. Elisa, you ready? Jim? All right. We're going to move on now to file number 20-24, 15 Delaney Road. This is another appeal/remand hearing. And our file is 15-22. What page, sorry? Yeah, 158. Just looking right at it. Thanks, John. Thanks for the help. Okay. So the appellant, speaking for the appellant, is Attorney Kristen Gagalis. The floor is yours.
Thank you, Madam Chair. My name is Kristen Gagalis, and as Madam Chair said, I'm here on behalf of Chris Quick, the appellant in this case. So, as you have heard, as you just heard the chair say, we are here on remand of that case, and the legal issue in this case is precisely the same as the legal issue you just spent the last hour and 42 minutes. Thank you. The legal issue is the same legal issue that you just spent the past hour and 42 minutes hearing about and discussing. It is whether the Keith's use of their property at 15 Delaney, their short-term rental use, is an accessory use. So I think we will all be happy if I do not belabor the definition of an accessory use, because that's clear. But what is different about this case is that it's on a different procedural posture than the Ward case. Whereas in that case, we had gone through discovery and went to trial, and the judge made findings of fact on the case. Here, that did not happen. The case was remanded along with the Ward case without factual findings. So part of the board's role is to make those factual findings. And in support of that, I know there has been a number of materials submitted to the board for today's hearing. And so I will be pretty brief, but I just want to briefly touch on what's noted in those filings. So in the Keith's filing for today's hearing, they noted that their house is rented, and these are the numbers, I believe, both in the affidavit and in the memorandum, short-term rented between 60 and 113 days a year, and used for personal use between 50 and 120 days a year. Those numbers alone make short-term use, in our opinion, not the principal use. However, what's important for the board to do here is make clear factual findings, and those numbers are a very wide range of numbers. 50 to 120 days a year is between, a month and a half to a quarter of the year. So I would encourage the board, as you will see in our submission that we made, to ask the necessary questions to make those factual findings. The Keiths themselves note in their submissions that the number of personal days they list is an estimate. And I know there has been significant discussion about how to count those days, whether it's difficult to keep track of them, et cetera. But I would urge the board to make a clear factual finding on the number of personal use days that the Keiths have at their property. They note in their memorandum and in their affidavit that their personal use consists of that of family and friends. And as we were discussing earlier, family and friends would fall under the category of residential use. But it's less clear to me from reading the submissions exactly how many days the property is rented for and to how many different parties and the nature of that rental use. I know earlier today it was said many times, the board is making specific factual findings on specific cases. So I would encourage the board to ask the questions that we have submitted in our filing to discern the nature of the Keith's short-term rental use of their property. Calling into question sort of the number of days that they use it for their personal use, I do believe that they own other properties on island, and that they noted in their own memorandum that they have a family member who has a home, I believe, also on Delaney. And so whereas in the Ward case, there was a garage apartment and the home is the Grapes' only home on the island. So presumably when they're here, they're staying there. That's a little bit more in question in this case. So I would urge the board to make clear factual findings in that regard. And I will be available to answer any questions, but I thought you'd all appreciate if I was brief. So that's about all that I have. Thank you.
Okay, thank you. And Attorney Bailey?
Thank you, Madam Chair, members of the board. I'm Dan Bailey. I'm a land use attorney at Pierce Atwood in Boston. My colleague Kathleen Heyer and I have been representing the Keiths in this matter. We haven't appeared before this board, but we have represented them in the land court proceedings. I can answer one of those questions immediately, which is that Bonnie and Ralph Keith, who are my clients, only own one house on Nantucket, and that's the house at 15 Delaney Road. I know that there's been some confusion about this, but their daughter, Karen, owns a house around the corner. Can't remember the address, but it's nearby. And I'll get into a little bit more of that, as I have my comments. Like Attorney Gagalis, I'm going to try to be brief, but the facts here are different than the facts in the Grape case, and I think they make an even more compelling argument for an accessory use. So I'm going to ask the board to indulge me at least to get those facts on the table. All of the information is in your packets. There's a letter from me along with an affidavit from Mr. Keith, and also quite a good email from co-counsel, which is Mr. Cohen, and like Mr. McLaughlin, we're all praying for his rapid recovery. Stephen and I had set this up so that I'd go first, he'd wait for all the comments, and then he'd come in and finish it. That's a convenient way to be able to do things, but I will speak for him here today, and I will even be quoting from his memorandum. The first thing I want to be clear about, this I think it's a little bit of a distraction. You hear discussions during the Grape matter, and I don't think it'll come up in this one, but about the commercial STR uses. That's not what we're talking about here. These are individuals who, like many individuals, have owned homes on Nantucket for over 30 years. They are the classic textbook case of someone who purchases a home on Nantucket as a second home and rents it out to be able to pay for it. They've been doing that since 1988. They first had a house over on Barnabas Lane that they purchased, 1988, 1989. They owned that until 2016. At that time, they purchased the current property at 15 Delaney Road. They had a house constructed on it. It's a 4-bedroom, 4.5-bath house. They use it for their personal use. Their daughter Karen and her husband use it when they are on island, which is sometime when Ralph and Bonnie are not on it. Karen and her husband actually spent I think it was a couple of weeks here last winter in their house, but going over to 15 Delaney to supervise the replacement of a fence. So, the days that are in the affidavit and are in the in our letter are the estimates. You're kind of thinking about how they've used the house over the last 5, 6, 7 years. There will be some years where they may have been here themselves over 100 days. There are some years where they may only have been here 50 or 60 days. There are some years it's short-term rented more. During the pandemic, good example. There are some years it's rented less. But the ranges that we provided in the materials and that were quoted by Attorney Gagalis are accurate. Again, just, Attorney Pickering-Cook in her comments said that the traditional use of vacation homes, not in her comments today, but in some of her papers, on Nantucket, they were rented to help defray expenses so that they can afford a Nantucket vacation home. Again, that's what the Keiths have done. You know, we've heard an awful lot, and I, again, won't get into it, but to me, this case is all about what is customary. And that is what Judge Vey is looking to this board to determine. What is customary in your community? You know, it varies greatly by community. There's no question that short-term rental or rental of a house, you know, for a short amount of time is not customary and incidental in places like Linfield and other Boston suburbs, like places where Mr. Pucci and I live. You know, I'd like to go back and just recount a little bit of history. You know, Mr. Keith and his family had property on Nantucket going back to the 1940s. Mr. Keith, in fact, went to elementary school in Nantucket in the 1950s. He honeymooned here in the 1960s, and when he could afford to buy a house, he did buy one on Barabas Lane, again, about 1988. He and his family maintained that house entirely by themselves. They repaired it, they painted it, and yes, they short-term rented it. After about 25 years, as they got older, they were not able to keep up with the maintenance on that house because it was an ancient and, you know, a historic house. And that's when they decided to sell it and to build the house at 15 Delaney. The family manages the property at 15 Delaney very closely. They still do quite a bit of the upkeep. They manage all of the contracts, even though some of them do come through brokers. They review the contracts and sign them personally. They limit the number of people that can rent there and have had little or no issues with their renters over the years. You know, I don't want to belabor this, but I do want to get into it a little bit. And I've been working on Nantucket long enough to know some examples of how accessory uses here are different than they might be someplace else. And one of the ones, I may have even had a case before this board at one point, but I know it was a controversial issue, is the scope of which contractors can store contractors' vehicles, you know, landscaping vehicles in particular, in residential neighborhoods. And generally, a reasonable amount of trucks, one or two, you know, not 15, but generally on Nantucket, the contractors can have a truck or two in their yards, and there's not any issue about that. I don't know that it did come to the board. I think maybe somebody asked for enforcement, and the building inspector denied it and didn't go anywhere from there. You know, as we've talked about, there's been already abundant evidence submitted to this board that a short-term rental, which is a rental less than 30 days of second homes, is customary on Nantucket and has been for a very long time. You know, I'm looking at my notes, and so much of it is very repetitive from what we've heard before, and I know you've got a couple of other hearings, so you know, I don't want to belabor a lot of this. I do want to mention one thing, which I'll just say it's ironic, but when the Keiths had their house on Barnabas, one of their short-term renters were Chris and Ann Quick. You know, that alone, to me, establishes some element of tradition going back 15, 20 years. You know, another thing that we've talked about is the availability of that home to an owner. I mean, that's one of the indicia of ownerships. Those of us that are lawyers have all sat in property class and heard about the bundle of sticks that is ownership. And one part of the bundle of sticks is the freedom to come and go as you please. And this happened just a few weeks ago with the Keiths. They were sitting at home in Falmouth, Maine at 4 o'clock on a Friday. It looked like a nice weekend on Nantucket. The house wasn't rented. And they said, well, why don't we go to Nantucket? They took a 7:30 flight from Boston, and they were here Friday night and spent the weekend in Nantucket. That's something that an owner can do, that, you know, someone who's a renter who, you know, does not. You know, I purchased a second home myself in Vermont for exactly that reason, the ability to come and go whenever I want. also going to touch on the Madelone case. Nantucket, you don't have a definition of accessory use. So you would look, and George, you do have a definition, but you don't really have a definition of short-term rental. But the bylaw does provide some guidance on how the ZBA should, consider accessory residential use. And that's the used or to be used language that Judge Vey, against what I argued, we represented the abutters in that case, and we lost. But he turned that case in large part on the definition of dwelling, which is used or to be used. So if that's to have any meaning, it means any time that a dwelling is available to be used. Again, I didn't agree with the particular decision in that case. I thought that the house had been abandoned, but he emphasized that, no, this is a little bit, it just doesn't say used in the Nantucket bylaw. It says used or to be used. So, we urge the board to adopt a practical and workable standard. I think that's a very hard thing for you to do. This one suggestion that's been made is if it's, you look at it as a 365-day-a-year thing, I think that's certainly one way to do it, and we would encourage you to do that. And if it's rented more than 183 days a year, then rental becomes the predominant use. But I'm also personally kind of inclined to agree with Attorney Pucci, which is this is one, it's not necessarily that easy. That this is one of those things that can vary very much from house to house to house, and you need to look at it holistically. And I'd urge you that when you look at the Keith's use of their house holistically, they have used their houses, both Barnabas Lane and 15 Delaney, entirely consistent with the tradition of second home ownership and rental on Nantucket. Thank you, and I'm happy to answer any questions.
Does anyone on the board have any questions at this point? No. All right. Is there anyone in the audience who wishes to speak on this one? Do you have anyone on Zoom?
No hands are up online.
Okay. Of course.
So this decision didn't include facts, right? So we really are in a different posture? Or does the judge want us to, I don't know, analyze it in the same way?
Yeah,
without
that's a great
facts?
question. I credit Kristen. I hadn't actually thought of that it is a little different, that you don't have 3 pages of facts that you're bound by. So there have been factual submissions made as part of your packet, including what Attorney Bailey just summarized. I would suggest that you incorporate the record in terms of customary practices that was introduced in the Ward hearing, so that you don't have to have all the same people say the same thing. Beyond that, if you find that there are other factual issues that you really think you want to delve into, then maybe you're not ready to close the hearing today. Maybe you want to hear it, have one more hearing session. If you think everything's been submitted, though, you would have the ability to make findings of fact based on what was presented as part of that record. Like there's been an affidavit, for instance, submitted by Mr. Keith. That's certainly, the basis for factual findings that you could make.
Okay, and I think we can use the original case before us. We can use the facts from that, obviously, right? From our original decision.
Yeah.
Okay. Hold on one second. So Billy, all the letters that we received from the real estate brokers talking about customary, were those only, they're not, included twice, but are those part of the record for Quick as well?
That's the way I did it, rather than just, regurgitate the same pages over. I believe there were a couple letters that did either call out the ward matter or call out the quick matter. So that's where I stuck them in one. And then if it was general, I kind of just shoved it in with 9 Westover for now because I knew that was going to come first.
Right, but I mean, as far as like the record for, I outside of the physical packet, like those letters are part of the record for this other one?
Yes.
Yeah, okay. And I agree with George that we should, whatever the testimony that was given for Ward, that was like from Penny Dye and other community members about customary use should be included in the record.
Yeah, there were
for this.
opposition letters in there as well.
As well, yeah, all of it.
Yep.
Do we make a separate motion?
I don't know, George, how
I think that would be a
procedurally?
great idea,
Okay.
really, to formally move to incorporate
The public
any-
comment?
the evidentiary submissions
Okay.
from the Ward case into the quick case
Okay.
as well.
Would someone want to make that motion?
I'll make that motion.
All right, so John Brescher makes the motion. Do I have a second? I think Elisa went first, so Elisa's going to second it. Okay, so voting Elisa over, all those in favor of including the evidentiary materials from the word case to the quick case record, please say aye.
Aye.
Aye, okay, great. Okay. Sure.
I just wanted to add in terms of, you were just discussing what you can go off of to make factual determinations. I just wanted to add that in the trial for the Ward case and throughout discovery, the Grapes provided significant evidence of their use in terms of like calendars and notebooks and things like that. Here we just have one affidavit stating a very wide range of days. So it would certainly be the board's prerogative to ask for more evidence of that actual use rather than just one affidavit with a number of days. Thank you.
Only because we're in the context of litigation. I'd be careful about that.
I wasn't going to pursue that.
I would open up that question 2 ways. If the board members think that there's further information that you need on this record, keep the hearing open. If either the plaintiff or even the defendant or anybody from the community thinks you need more information, I'd take that under consideration in terms of whether you're ready to close the hearing or not. So I'd just be cautious that way. If you think you have a full record, then you'd certainly be ready to close the hearing.
Does anyone on the board feel the need to require or request more information about the details? I mean, we have the affidavit from the Quicks.
I don't.
Yeah, I don't either. Okay. Thinking about the, does anyone have any, do we want to discuss or have any questions about the anytime the dwelling is available to be used in the, and Jim, how you were saying it's not the, not just the summer months, like thinking about, in the opposite way, right? If someone's here to use their house from the summer, but there are those people that rent their house out for the off-season, right? The October through May rental, which I believe gets you over the 182 days, which I think then makes, like, I just think we need to be careful when we're thinking about like a hardline day, but it's just my.
I don't think it should come up, but to me, the 182 days is an escape hatch. I mean, come on, the money's made Memorial Day to Labor Day. That's when the main renting is going to go on. Not that people don't rent at other times.
Yeah, but
It will affect.
right, but it impact, what I'm saying is that impacts, we're not, the decision, it's going to have ripple effects on other things. So having, it cuts both ways if you say that it's that hard number line.
No, I'm not arguing with you. I'm just saying, I personally think that those days are the more important days. I don't think it says that in the bylaw. I mean,
Yeah, I agree with you, Susan, but I also agree with you that,
Well, the bylaw's silent.
yeah, but, again, and I didn't clarify this, but in the Ward case, similar to this case, the reason why that's important is because there are many days that you don't have that noise and all, and you need to take that into account. I mean, and usually it's because it's not occupied, but that to me is important, not just the money.
Madam Chair?
Yes.
Just to, I don't think you've closed the public hearing
haven't
yet.
yet.
So just to clarify on that last point you raised about the renting off-season, I would just urge the board there's not a conflict or there's not an issue you need to take care of if you're renting off-season for long-term. That's residential use. That's covered under your bylaw. So if you're talking about renting to someone for 190 days as a school teacher, that's not impacted by your decision here. That's a long-term rental. Your decision here is only, and that's residential use. The decision you're dealing with here is the accessory use only for short-term rentals.
It's in our bylaw that
Yeah, so your bylaw doesn't talk about it explicitly. The cases talk about the fact that long-term rental is residential use. So the cases don't differentiate between whether someone owns a home or whether they're renting a home. The use is residential. So the fact that someone rents for 3 or 4 or 9 months, that's residential use. What the cases have said, Styler and now the Ward case have said is the short-term rental, under 30 days, that's not residential use. So that's the difference. Your bylaw deals with residential use quite clearly.
Okay, so I see Mr. Bailey has his hand up.
I'm just going to push back a little bit on summer being more exclusive. I mean, obviously, summer is more important when people are renting than other times, but, stroll, Thanksgiving week, I know from clients that their seasons are very much expanding into the fall. So I think it's, a little difficult to draw a very specific season. I think we could probably agree that January through March are pretty quiet, but the rest of the year, people are renting, and they're short-term renting.
Can I ask one thing? So if you and I go partners on a house here in Nantucket, I'll take the summer rentals and you take everything else. Is that a good deal? We're gonna buy the house 50-50.
Well, you pay, the proportion of the income on the mortgage, okay. I'm not disagreeing with you that, that summer is where, where the value is, but,
Right, but but we're not talking about how much money people are making, so that doesn't, that's not the crux. The underlying issue is, right, the amount of time that people are spending either in the house or renting their house or not in their house. And so it doesn't, I don't see our concern has anything to do with whether that happens in February or it happens in, 4th of July week, or if they pay, $100 or $1,200 or whatever. That doesn't matter to me. In terms of this discussion. Okay, I don't see anyone else in the public who wants to speak. Is no one on Zoom? Okay. Does anyone have any questions left for either of the attorneys?
Actually, I do.
Sure.
Madam Chair, through to Mr. Bailey. This is a single-family residence, correct? So it's only one.
I should have mentioned that. It's one single-family residence. There's no secondary dwelling or tertiary dwelling. So,
Okay.
yeah.
Thank you.
Okay. Okay, I think then if we don't have any other questions, we could move to close the public hearing and move to deliberation unless we want, unless we think we need more information from the homeowner.
I'm okay with the affidavit.
Me too.
And what we've heard today.
Motion to close the public hearing.
All right, so Elisa,
Second.
Elisa makes the motion to close the public hearing. John seconds the motion. Again, voting Elisa over. All those in favor of closing the public hearing, say aye.
Aye.
Okay, so the public hearing portion is closed. Oh, okay, so now we're at 3:10. Maybe we should deliberate till 3:30, say where we are at 3:30, then that'll give us another hour. Right, we have till 4:30, you said, yeah?
Yeah.
Okay. Okay. I'm just gonna go down the same way I did the last time, and hopefully that'll spur some discussion and some idea of where we are falling on these issues, or this question, rather. Do you want to start off again, Joe?
Nope.
No? Okay. You'll start, Michael?
My comments are very similar to the last case, and I think they've been recorded. And that's all I have to say.
Okay. Elisa, would you like to weigh in?
I also feel the same way I felt about the last case.
Okay. Jim?
Yeah, I have the same comments, even as the last case, but this is even, for me, an easier case. Even though it seems the numbers are, is that right? The rental numbers are higher. I just think this is more in line with what the bylaw allows.
I tend to echo Jim on this, especially, I realize there are similarities between this and the Ward and Grape matter, and there are differences here as well. This seems more in line with, I think, how people traditionally have rented and used properties out here. And again, I think I'd echo the same comments, and I too would, much like the last matter, and prefer to see a decision before voting.
Joe, do you have anything to add?
No, I actually haven't made my mind yet, so I'll wait till we see the decision, the draft.
Okay. I echo what I'm hearing as far as I think that this use, based on the affidavit, based on the information presented to us, this seems to fall squarely in line with how homes on the island have been used for a very long time. And I also think it's interesting, and I don't know if Jim brought it up or Attorney Bailey brought it up, but that, the Quicks actually short-term rented from the Keiths at some point, and also that in the other case, the Ward family didn't rent from the Grapes, but they did for years rent, and that was their entree onto the island and getting to know the neighborhoods and figuring out where they wanted to be able to be. So, and I think that also in some way shows in both instances, the people who are, appealing the decision that we gave, both rented on Nantucket in a short-term capacity and then purchased homes here, whether they rent them or not. I think that's another custom and tradition that's been around for a long time of how people get here, decide whether they like it, decide whether they want to stay, and eventually, purchase a home and then, maybe rent it out to be able to afford it and keep it. All right, I would also like to see a decision before we make a final vote. So if the board is in agreement, we could perhaps continue this one as well to the August 15th regularly scheduled meeting, review that decision, and see where we are then if we have additional revisions or changes to it. Okay. Does that sound, anyone have anything further, any questions, any comments? No. Okay, then I would entertain a motion to continue this to the regularly scheduled August 15th Town of Nantucket Zoning Board of Appeals meeting to give George some time to get the decision to us.
So moved.
Okay.
Second.
Okay, so John makes that motion, Elisa has seconded that motion, and everyone, so Elisa down, will vote. So, sorry, so the sitting board is Elisa, myself, Susan, Michael, John, and Joe. So all those in favor, say aye.
Aye.
Aye, okay. So we will pick this back up in August. Yeah, okay. Thank you, everyone, for your presentation and your information. Thank you. Thank you for your time.
Thank you.
That wasn't always the case.
I was thinking this morning of some fond memories from last summer.
Great summer, wasn't it?
Yeah. Our kids did great in baseball. Our kids did great in baseball.
Yeah.
Just to, you could blanket, continue the two old business rather
Yeah.
than blanket continue the two new business. I'll do two motions to continue both, or Sarah, are you gonna continue that?
Yes.
Okay.
Yeah, sorry about that. Okay. Well, let's.
Yeah, we gotta.
We do. Oh.
So continue everything else?
No.
We have the last two items.
Did you call for a break?
Elisa had used the restroom. So that. Okay. So I'm going to continue or ask to continue 1424, 1824, 1224, and 1922, 24.
24, yeah.
I can do all. I'm not just. Can I do both of those? All of those in the business? Okay.
Billy, do you know who's sitting on these cases that we're gonna? Here. Oh, these are new?
The next one, the 120,
Oh, this is new. Okay. I thought it was-
126 name.
Oh, yeah, that's what I was thinking of. Yeah, I thought that was a.
Okay, so we're back. We're going to, I'm going to look for a motion to continue to August 15th, 14-24, 10 Main Street and 1 Gully Roads, and 18-24, 43 West Miacomet Road.
Actually, Sarah, do you want to continue to next Wednesday, or do you want to continue to the 15th, August 15th?
Well, we don't know, yeah, I guess we're scheduled to meet next Wednesday, but the 3 applications are Steve's.
Oh, so you might not go. I mean, I don't know because everybody left. I could ask them. You want to continue to them, and then if you go forward, great, and if it all falls apart, I'll go to August.
Okay, let's do that. Okay, so the 17th is next week, and then the 15th in August. Okay.
17th at 1?
Yes,
Yeah.
and it's a Wednesday, just to,
Is it in this room?
yeah.
Okay. Okay, so we're looking for a motion to continue old business items 14-24 and 18-24 to July 17th, 2024 at 1 o'clock.
So moved.
Second.
Okay, so John has made the motion, Elisa has seconded the motion for 1, 2, 3, 4. Okay, so I guess all those in favor say aye.
Aye.
Aye, okay. And then, so that carries, and then I also need a motion, please, to continue the first 2 items in new business, 12-24, 19-24, to July 17th, 2024 at 1 PM.
So moved.
Elisa makes that motion.
Second.
John seconds that motion. All those in favor say aye.
Aye.
Okay, so those are continued. And Sarah, we will let you know through staff if that changes for the 17th. Okay, all right, moving along. We have application 21-24 KMS 126NT, 126R Main Street, Linda Williams presenting. And this one, I just want to make sure everybody got the, there was a letter that we received that was not in the packet from the owner of 128 Main Street, just to make sure everybody has that. Okay, all right. What? Sure, you can, yeah, you can have my copy.
Oh, yeah.
It's small, small print.
Yeah,
Oh, you have it? Okay, well,
there we go.
all right, and then can I have one back at some point?
Wait.
No, the one from,
Thanks, Linda. Outstanding.
when Sarah reads the letter, then she's gonna give it to you to look at, and then I'd like it back. Okay. Moving on. All right, Linda, can you just, before you make your presentation, what's this letter you just gave us from?
This, we just got it today. The engineer, the structural engineer, wasn't able to get over here until last week, and he just sent it to me this morning, related to the garage structure, which dovetails with my request to be able to demolish it and put it back exactly as the HDC approved it. I'll give you the rundown while you look at that. We've been 2 years trying to get through the HDC. Most of it was on the foundation replication of the main house. So that was all approved. It was these lots, 126 and 126R, for the record, Linda Williams, 126 and 126R Main Street were subdivided or divided based on a 4181L. They're both actually over the 5,000 square foot minimum. It was the largest lot on Main Street like that. And the garage went with the rear lot, and the house went with the front lot. And we spent 6 months, if not more, going through the HDC on what to do with this car garage, not a barn and not a stable, that we wanted to move out of the setback, and the HDC, he said no. And they did allow us to move it back 12 feet, so we can get it out of the front, the setback behind the main house onto it, further back on its own lot. And they only allowed us to move it out to 2.7 on the front corner and I think 2 feet on the back corner. We've had an issue with this all along. You can see by the pictures, as well as the pictures that the engineer included, but I gave you a full set of pictures in your packet. We argued about this, and we needed the engineer to come and validate what we already knew when we took the ivy off the structure. The structure was almost completely covered with old growth ivy, and nobody knew exactly how bad the structure was until we took the ivy off a few months ago. And it is not in good shape. You can see holes all through it because we're not allowed to move it out of the at least 3 feet away. We have to recreate the east wall, which was really the only wall without significant changes being made to it, because now it has to be a firewall, and it doesn't meet anything that related to code. So we're stuck with this structure that we know we can't pick up, given the way it was stuck onto a board in the ground, and with all the compromise to it, and the engineer says it's unsafe to move it over there so we can fix it and do all the stuff the HCC did approve to it, and then try to move it back to where they allowed us to move it back to. It will not survive the move. We don't have anything to brace to pick it up and move it. We have nothing to pick it up with, because it would have a garage door, an overhead garage door in the front. The structure does date from somewhere in the 1920s. We're able to pick it out at that point. But we're having an issue with this thing, which is why in my addendum, I asked to be able to leave it where they approved it. And then also to be able, should it not survive being picked up, which the engineer says is unsafe, it may actually fall on Sarah's client, because that's the only intact wall. We're asking to be able to demolish it and put it back as the HCC previously approved it. At 2.7 in the front, I think it is, and 2 feet in the rear. So we're sort of stuck with this structure. We were hoping that it would just fall over by itself when we took the ivy off, which was entirely possible. So we're sort of stuck here. So it is a special permit because it's already in the setback. It's X0 setback from Sarah's client at 124. So this is the conundrum. What do we do? If you allow me to pick it up, move it, put it back, not going to happen. It's not going to survive the move. Or allow me, conversely, to demolish it and put it back where the HDC is forcing us to put it back after several months of arguing with them. All still a special permit because it's going back where it was. If you look at the HCC approval,
I may have misheard you. You said if you allow us to demolish it and pick it up?
no,
You didn't say
either
that.
way. I said
Okay.
either way.
Okay.
If you look at what the HDC approved, we have a whole new garage structure on the front, which has to be reframed. We have French doors and a window on the west side facing into the lot. Nothing's left of that wall. In the back, we have a dormer and I think French doors going out the back, which there is no back to the structure if you look at it and look at the engineer's pictures. And now we have to rebuild the east wall because it doesn't meet the fire code. And we have to take the roof off and fix the roof because there are dormers going on and stuff like that. What do I have left? That was our argument with the HDC. But so we're ping-ponging back and forth between the two. But if part of your approval allows me to demolish it and put it back, given the engineer and everything else that's been allowed to happen to it, then I'll go back to the HDC and have that argument with the HDC all over again. Because we don't have any intention of building anything other than the footprint that it's on. We don't want to expand the ground cover, though we have plenty of ground cover because it's over a 5,000 square foot lot. The only anomaly on this lot is the fact that it only has 10 feet of frontage up the existing driveway. But otherwise, the lot is completely conforming, except for the garage is sitting at 0 setback. So, I mean, so we're just here to get some help on this.
Elisa needs a clarification, please.
Sorry, I might have missed a couple things in there.
Oh, believe me, it's been 2 years of
I
a
mean, I
saga.
know you talk about it every day, and I just want to grasp exactly what's going on. Okay, the structure has never been lifted off of where it is right now. So when you say put it back, you mean rebuild it on the same footprint that it's on right now?
It's got to go over there to the lot, into the lot, in order for us to do a foundation underneath it, because it's got no foundation.
Okay,
all the
what is the
revisions to it
what
and
is
then
the
move it back.
HDC approved?
Yeah, thank you.
The HDC, they know it's going over there and coming back, because we have to put a foundation there.
So you're going to pick it up, move it over, put a foundation in, and then put it back on
And
it?
rehab it over there.
Rebuild it.
Over there, and then move it back. And he said it's not going to survive the move, and it isn't going
Okay,
to
I don't
survive
care,
the
well,
move
that's
back.
not, so you need relief from us? Just to move it. Just to move it.
I'd love it to be demolished and put it back
But
as
we're
an
not,
alternative.
we can't give you the.
Yes, you can. I've done
Demolish and
many
put it
times.
back doesn't make sense.
No, that's a demolish permit from the HDC.
Yeah, I'm going to have to go back to the HDC, but your decision should be, if you do that, is to allow it to move out and go back to where the HDC approved it.
Yeah.
And then conversely, if it doesn't survive the move, which everybody knows it will not, to allow it to be demolished and put back exactly as the HDC approved it. Back.
Well, I think if it falls apart, if it,
then it's
yeah.
brand new.
I don't want to come back to a second time because it fell apart. That's the point. So you
Madam
can do
Chair,
either
Oh, I
way.
see what you're saying, okay.
Yeah.
What-
I think what would be helpful, look at page 248. It's the HDC approved site plan that shows where the garage is moving to.
Yeah, thank you.
It's already allowed by them to move back 12 feet and out 2 feet.
And it's not going up anymore.
No.
It's exactly the same.
Same envelope, except that we're obviously adding a dormer, windows, stuff like that.
Why wouldn't we let them do that? I'm not getting what the conflict or what the problem is. Maybe I'm not as seasoned.
I
at
think
this
she
stuff.
just needs to, you're just here because you need to retain, because you're moving it off to rehab it, to put the foundation in, you don't want to lose the
The setback, because they
this
they won't give it
pre-existing
to us.
non-conforming setback?
Yeah. We don't have a ground cover problem, we don't have anything else.
Okay.
Even though the setback will be less non-conforming,
Yeah,
correct? So we're going from a 0 foot to as close as
2.7 and 2
change.
feet.
Okay.
Okay.
But I just need the decision to encompass if it survives the move or if it doesn't survive the move,
I
to be
have a
able to
feeling
build
it's not
exactly
going to.
what the HDC approved.
Go ahead.
Well, I think we should just give permission that something, some configuration ends up at 2 and 2.7 feet away from the lot line.
Yeah.
If it's a rehab, reconstructed, fine. If it's new, that's fine too. We don't care about demolished. I don't, I mean.
I don't either.
maybe you
Yeah, I
guys
think permission. We're
Right.
just
do.
saying,
You can put something there,
Something.
yeah, a building.
And it's going on the exact same footprint that it's sitting on now?
No,
Or it's getting expanded
No,
because of the
it's the
foundation?
same square footage. That's the point.
In a different spot.
In a
that's
different
less-
spot.
Less conforming.
Because we've already been allowed to
Less
move.
non-conforming.
More conforming.
yes,
conforming,
less
right.
Thank you.
non-conforming.
Yeah.
Okay.
And it moves out of the front yard
I
setback.
don't
So
have a
you just
problem with
want to,
that.
you just want to be, you want to preserve the pre-existing non-conforming status of this structure, even though it's, the original one is going away.
Even if it's only off for 1 minute.
Yeah.
Right.
Yeah.
You're not losing your right to use that
You get a special permit.
for, okay.
Yeah, so
I
we don't
vote
have to talk
approve.
about the demolition or anything, we just have to.
Well, I need you to talk about the demolition, because if
No,
because
we
if it's
don't.
demolished, and I rebuild it exactly as the HDC approved it,
But if we
I'm
write
still
it up.
back at the 2.7 and the 2, so I'm trying, the special permit will validate that setback, period.
We're gonna give you a footprint.
Yeah,
Yeah.
you're already telling us the
What do you do with
footprint.
it, what you
Yeah,
want?
we don't need to know if it's the original or not
we
the
don't care.
original.
Oh, yes, I do.
Well,
No, you.
That's your
HDC.
problem with HDC,
Yeah.
though.
No, if you've got to allow me to not keep the existing structure and rebuild the structure exactly as the HDC approved it back at that non-conforming setback, your decision has to allow that. if it falls apart.
But we can't because you never asked for 13933A4.
Yes, I did. I asked it for both of them.
Really?
I have it in my addendum where I asked for both, and it's in the public notice.
13933A4?
That's the demo section.
I don't see it.
Look at the addendum.
I'm looking at it, Linda.
Yeah, me too.
I spelled out in case it doesn't survive the move, specifically said that. Then I'm gonna need, the same special permit to validate that, that non-conforming setback for whatever.
We basically want to build a new structure on the same footprint that exists right now. That, in so many words, whether or not it survives or
Not
not.
the same footprint. Back 12 feet is they allowed us to go, and up to 2.7 and 2, because it's exhibit right now.
Okay.
It's a lot simpler than what this is being made out to
Yeah,
be.
sounds.
It's just a pain.
So this just says that you're seeking special permit relief from 13933A1B, that the proposed extension, alteration, and change to the pre-existing non-conforming single-story garage structure will not increase the non-conforming nature of the structure and will not create any new non-conformities.
It'd be actually less. But yeah, but in the addendum, it also says, should it not survive the move, then I'm asking to be able to replicate it as the HDC originally approved. Exactly. So the structure is still going to
And
look the
where
same.
did you write that?
And I believe it's in the notice.
I wanted to chime in here.
Sure.
We did not notice for that
Well, you and I
bylaw.
talked about that.
It was after the fact. That was when I was doing my staff report. So we did not have that noticed.
I don't think it's in, and I don't think it's in this addendum either, unless I'm
It
reading over.
was, because you and I looked at it.
Looked at what?
The addendum, when I brought it in.
Right today?
No, when I filed it.
No, this is inaccurate. Your addendum is right here in front of us. We had a conversation, you had come in when I was crafting the staff report because I had a ton of questions about it, and that's when you brought up this additional fact, which it made sense to me, but I didn't think about the fact that we didn't advertise for it, so I don't think it's something they can vote on.
No, we can't, because even here it says, based upon the foregoing, a ZBA decision could be issued granting the requested relief, which is what I just read, allowing the relocation and renovation of the garage structure as noted above, based upon the finding that the expansion would not be substantially more detrimental to the neighborhood than the existing garage, and further finding that the relocation would reduce the non-conforming nature of the garage, which is to be relocated farther from the easterly side yard lot line. The decision could be conditioned upon compliance with the HDC COA, which does not contemplate demolition, and no further expansion of the garage within the required 5-foot side yard setback shall take place without further relief from the ZBA. So,
Right, but my language is way up at the beginning, not back there. I added
well,
that section.
Linda, I just skimmed it, and I can't find anywhere that says doesn't survive demolition or any of that. So I don't see it. If you can show it to me, then I don't know, maybe I've read too much today, but I don't see it. So
think?
I think we can
You can
do what we
validate that.
typically do in a situation like this, where someone needs to move an old structure, and yes, sometimes they're rickety and sometimes things might happen. But I think if we give it, if we bless it, that it's not gonna lose its status by being moved off, then it doesn't really
Matter what goes back?
matter what goes back, as long
Okay.
as what goes back conforms to the setback, the footprint, and everything that's on the plan that was approved.
Okay.
I think that's how we've done it in the
If you stay away from what
past.
structure goes back, and then you're validating the setback, and that's fine.
We're contemplating whatever you asked us to do.
Okay.
So,
It says in paragraph 1, should the garage become irretrievably compromised in the relocation effort, given the unstable condition, the applicant is requesting approval for the demolition and
stand
reconstruction.
corrected. I
There you
read
go.
right
I know
over
it was
it.
in there.
I did. I must have read too much today. Okay,
I know what I wrote, sometimes.
okay.
For the
But it's-
demolition and reconstruction, yeah.
So if you just validate the setbacks, we'll deal with the HDC then.
I still don't think we want to touch demolition. I don't think we've ever done
That's
that.
not within our
That's-
purview,
I
right?
think that's an HDC.
All right, then just validate the setback then, the sighting.
Yeah.
The sighting that they approved and the setback that they approved.
Madam Chair, I think this lady wants to.
Yeah, I know.
Oh, you didn't know that?
Yeah, I did see her. No, that's okay. Does anyone have any more questions for Linda before I go over here?
I reserve the right to rebut.
Reserves the right to rebut.
Are we on Judge Judy right now?
We are. I am Judge Judy right now. Okay. You have the microphone. Just identify yourself for the minutes.
Thank you very much for recognizing me to speak. I'm Hillary Hedges Rayport, resident of 89 Main Street. So I really have a series of questions and would like to share some of my thoughts about this application. So the rear lot, which contains the driveway, which is less than 11 feet wide, and the pre-existing garage was created under a 4181L division of land, as you all know. In 2012, at Nantucket Town Meeting, voters passed a technical amendment, technical correction, it was called, that conveyed pre-existing non-conforming status on all lots and structures on the lots created under Chapter 4181L, which effectively means that these non-conforming, if the lot that was created through 4181L is non-conforming, it's vested with pre-existing rights as long as the structure on it had been existing prior to 1955 subdivision control. So now, after that 2012 vote, these lots that have been created irregularly, in some cases, around these dwellings that existed prior to 1955 are now buildable. And Nantucket is the only town in Massachusetts. I've spoken with a couple lawyers, and I also spoke on Monday with the consultant who's going to be updating the subdivision control. I had the opportunity, because 4181L divisions of land on Nantucket came up, to ask him, are these lots considered pre-existing non-conforming? Are they vested? Are they buildable in any other town? He said, no, I'm not aware of that. So I'm just giving you that history to let you understand how unusual this is, and I do understand why it is done, why it was done, even though it was very unusual. There are lots of unusual things done on Nantucket. But I think for the questions and the consideration that I'd like this board to give is that this case is now coming before this board, and it is not just a matter of picking up and moving the structure 12 feet and partially out of the side back. It is about a program for the lot that materially worsens the nonconformity. And the major nonconformity is not the setback. The major nonconformity is the less than 11 feet of access through a driveway less than 11 feet wide that has structures hard by it on either side. A fire engine on Nantucket is 104 inches.
Point of order, Madam Chair. This is irrelevant to the
It's not
request.
irrelevant, and I'm sorry,
Let's
Madam
just
Chair,
let her,
please.
I'm happy to listen to her comments for now, and we'll see where we go.
Well, I guess I would like to ask if it is irrelevant, because I certainly don't want to waste your time. I mean, I'm a resident of this area, and what we're seeing is areas that really do not conform to our zoning, which is there for safety. It's there for livable neighborhoods. It's there for aesthetics. That's what we're upholding. And we are getting a much more congested, the HGC plan shows, another dwelling. The use of the garage is changing. It will no longer be a garage. And the whole idea of 4181L was for substantial structures. I guess that's probably irrelevant, but I guess I would ask the board, the nonconformity, developing a new dwelling with multiple structures, outbuildings, main house in this rear lot that literally has only 10.98 feet of access how are we not worsening the nonconformity, which this board potentially has a chance to step in and uphold the zoning, keep the zoning intact, because now we are seeing that the structure is moving to accommodate the programming. Thank you.
Sure. Yep. Sure.
Don't
Michael.
forget my rebuttal.
Okay.
About halfway through your remarks, you mentioned something about an engineer who is going to be, who claims that the 81L, I think this is what he said, maybe he didn't say, I just want to make sure, that the 81L was not legal in any other community in Commonwealth?
So 4181L divisions of land are a state, they're legal everywhere. Yeah. But what the zoning case law, as you know, shows is that creating a new parcel based on the 4181L exception for pre-existing structures does not convey Section A rights. It doesn't convey that by law. So he absolutely can parcel off this piece of land, but it's only on Nantucket that he doesn't have to come to you for a variance and to request pre-existing rights, vested rights.
There used to be something called the field doctrine.
Yeah.
Back in,
Keep going.
yeah, is it 83?
It was 80, 85 or 86.
Yeah, and Sarah would, or maybe somebody else could better describe what happened after that, several years after. But it was originally a big deal to get an 81L approved. And then they were handing them out like popcorn.
Yeah. And you can divide it, and it might be that you've created a conforming lot, in which case there's, no additional, I mean, I don't mean to tell you things you already know, but in this case, the lot is non-conforming. It creates I think it has a material detriment to the neighborhood by creating a second dwelling, a garage that's no longer a garage, but is actually livable, a lot of patio. There is a picture of the fire pit on the patio. I know that is ephemeral and someone may or may not want to do that. But it is a dramatic change in use for this parcel that is not accessible easily. Think about a fire engine. Fire engines have long hoses. The fire engine does not need to go into the driveway. The driveway, I think it says on the drawing that it's 60 feet. It could be filled with very wide cars. And then they could have made a longer driveway on the other side of the structure, but they chose instead to build out and expand a wing of the original pre-Revolutionary War house. So it is the programming of this lot that has created a much worse situation in terms of conformity. The use is changing dramatically. And I think it goes really beyond, well, as a neighbor, I'm not a neighbor, but I live in the community and there have been other places. I think it's really beyond the intent of what the 2012 change was after.
Is it my turn now, quickly?
Wait,
There are a lot of
I had a
inaccuracies
question, well, or a comment. So 4181L for us currently creates a buildable lot and grandfathers pre-existing non-conforming status. So so that, is just how it is. The driveway issue
is existing.
Okay, that's what I was gonna ask. So the driveway exists at this size right now?
Yes, it does.
And the new garage,
Or whatever,
what?
whatever it is.
Well, I'm just like the new garage location.
We wanted to go back farther, just so
No,
you know.
I don't care about that. I don't care about that.
to get away from the driveway.
Yeah, yeah. And then there's then there's a house that's going here as well.
We're still at the HDC with that.
And then but the garage part is approved.
Yeah.
And the garage, you're not asking for change of use for the garage.
It's a garage, and then part of it's going to be sort of like a sitting area. That's why it has French doors and stuff, to give it some use.
But there's no like plumbing or bathroom or anything like that.
I don't know, it's allowed. It's a ancillary structure. There's no ground cover issue. There's only the setback, which we tried to remedy. And just to elaborate, this is over almost 11,000 square foot lot on Main Street, which is highly unusual. If we hadn't gone a 4181L on this, we could have built exactly what we're building, in fact, even more, because 40% ground cover of a 10,000 square foot lot is twice the building that we have going on in this lot. And we are legally allowed to build on almost a 6,000 square foot lot.
Why don't you
So-
merge the lots then?
They were merged, and then we did a 4181L. So we have of over 5,000 square foot lots. The only anomaly on that rear lot is that frontage. That's it. And the garage is at 0, which we tried to correct. But as far as the fire access and anything else, it's the same as it was before, only the garage was right there, and you couldn't get around it between the house and the garage. And now we wanted to move it back even further, but they wouldn't let us do that. But it is not a secondary dwelling. It is a dwelling by itself on a lot where it is. The driveway is what it is. It's been that way forever. The people that own 124 are at 0 setback. They're in their setback. Everybody up there is in a setback.
All right, I just want to ask the board, how do we feel about part of this project being approved by the HDC, but not the whole project? Does anyone have any issues with that?
What is that? What do you mean by that, though?
Well, you said that the rest of whatever else is being done on this
Right, and
lot
it's
is
not
still
before
at
you.
HDC. I know, but I'm just usually like
I'm okay with it because really in a very sort of myopic focus, it's just the garage.
Right.
We have nothing to say about the driveway, unfortunately. I mean, that's
I agree.
more
Or the
planning than
dwelling.
anything.
Yeah.
Whatever. We have just the garage, and sort of the silly thing is, if they just demoed the garage, or got their building permit, or put a building permit for a main structure back there, and they could just demo the garage and do whatever they wanted. And
yeah,
Right. And I wouldn't
You know,
be here unless they
exactly.
forced me into the setback. We would not be in the we would
Right.
not be at the Board of Appeals. And the only reason we're here is because they won't let us move it out of the setback.
right.
okay.
May I ask a question about
Yes.
that? So my understanding, or my question is, if the use is changing, so if you have a pre-existing structure with pre-existing Section 6A rights, and the use is changing, and a much bigger structure is being constructed, how does this board look upon that?
It's not a bigger structure.
Are you talking about the garage structure?
Well,
or
this is where I'm a little bit confused, because I think, we always have to look at the intent here. And Linda didn't come here and give you the plans that are in front of the HDC. But the plans that are in front of the HDC.
I gave them in their packet.
Linda, she's talking about the other part of.
Yeah,
Because we didn't
yeah,
have it at
I looked at what was in the packet, and then I went to the HDC, Tuesday meeting website and looked at what was in their packet. And what's in their packet is a 2-story house with a basement, full basement, and the garage, which is getting French doors and is going to have a studio. It was described as a studio. And the patio, fire pit, and then another outbuilding. So I just think it's a little, I know that the statute, I believe that the statute talks about if you have a pre-existing non-conforming structure that is vested with rights, and you are dramatically expanding it, it's something for this board to consider the effect on the neighborhood. Now, what has been brought before you is just one of 3 structures that are going on this lot. And it is unusual in Nantucket because we do have this tradition of multiple structures on a lot, but really it's all one program, it's one development concept for the lot. This garage would not be being turned into just one structure. And Linda mentioned, well, the driveway's always been there. There's nothing changing. Well, what's changing in terms of the safety is that there was nothing behind this house. It was just a field, and in fact,
It was a garage.
the garage was always there, and it was much closer to the house. And what was behind the garage was nothing, and in fact, it was actually a parcel that was accessible from a different property because it was part of a different property that was merged into this on Bloom Street. So I guess just to summarize, although you are looking at one structure that is not changing, the whole property plan includes 3 structures. It will get approved by the HDC for 3 structures because they won't have any leeway not to approve it. And it will be, a compound behind another compound with a 10.98-foot access in the Old Historic District. And I would ask, as a resident, I would think this is detrimental. And I ask the board to consider that.
Okay.
Madam Chair, if I
Yes.
may, a lot of this is way beyond our purview.
Yeah, it is. The one thing okay, Sarah. Okay, thank you. I was going to just say that, in the ROH, the garage doesn't need a special permit or to change to a studio or be used as, or does
Garage
it?
studio, yeah.
No, I mean, they're both allowed uses in the
Okay.
use chart. And then
Okay.
also, I was gonna reiterate, the 4181L process does validate this entire lot, including the frontage, as pre-existing non-conforming.
Okay,
And that
yeah.
is not before this board as part of this request.
Right.
It is simply the setback
Okay.
issue.
Okay, so comments appreciated, but outside of our purview, most of them. But thank you for the overview. Sarah, did you have something to say, or did this gentleman? Okay. Sure. Okay, Sarah, and then the gentleman in the back.
Thank you, Sarah Alger. I represent the owners next door at 124. There are a couple things. We're opposed to the move of the garage. We want the garage to stay where it is. If it has to be reconstructed there or renovated, that's what we think should happen. So we don't think that this relief should be granted. If you were to grant this relief, I think you need to condition it upon no change in the use of the structure, because the applicant hasn't applied for a change of use of a pre-existing non-conforming structure. And any change of use in a pre-existing non-conforming structure under 13933A requires special permit relief. So it has to remain a garage. And if you want to entertain an application to change it to something else, that should be a separate application that neighbors should have the opportunity to come and speak to.
Because even though it's allowed by right, because it is pre-existing non-conforming, that use has, because it's,
Right.
has to, that triggers the need for the special
Correct.
permit. Okay.
Unless it was if it was brought in so it met the setbacks.
Right, then you wouldn't have
Then
to.
you would not have the issue, but where it does not meet the setbacks.
So Linda, what Hillary said over there, that it's, is it a garage or are you making it into a studio?
Both. The car is going to still go in it, but that piece over here can be used as, part of the backyard. It's a very tight fit there. However,
The car's
in
going to
my
go in, the
addendum, it
car's going to
does
go
say
in through
that.
French, I mean, because when you said French doors, I kind of was like,
Yeah, on
that's,
the inside of the yard. It does say specifically the use of that building in my addendum. Whatever it does, yeah. No. Current, you can't put a car in there at the moment.
so you're
We're keeping the use for the garage because they're going to need it. And then when the car is not in the garage, it can park in the driveway all it wants for the rest of its life. When it's not in the garage, the kids can sit in there, they can put a pool table in there, they can do whatever they want to it. That's why I wasn't playing games. I put it in my addendum that it was a studio/garage. The footprint is not changing, the height is not changing, contrary to what was just said. It is not expanding the structure, except we're adding a dormer in the back where that roof is rotted out, so we can get a door in the back, because there's not enough head height, because it's about this tall on that back wall. So we're putting a dormer over where the door is going to go, so you can actually open a door in the back of the building. They've already approved all this, so relitigating that is immaterial at the moment, because the HDC's already approved the exterior architectural stuff. And the move, they fought the move at the HDC, and then HDC didn't let us move it back farther, so there was a clearer driveway. The HDC only let us move back 12 feet. And then we wanted to move it a little further away from the setback from Sarah's client at 124, and they wouldn't let us do that either. This has been going on for over 6 months, trying to get
Linda,
this done.
this is the first time we're seeing this.
I know, it's the first time you're
We're
seeing it.
not fighting you on it. I'm just trying to get the information to make sure that we're doing it correctly, so that we don't approve something and then you're at HTC, they're approving a studio, but you haven't asked for studio.
I did.
You asked for change of use as well.
I put it in my addendum that it was going to be renovated or whatever, and it was going to be a garage/studio. So when the car's not in there, they can do whatever they want.
Clarification.
Go, Elisa.
Is there going to be a full basement, a crawl space, or a concrete slab
Slab.
under this? Just a slab?
Yep.
Why don't they just rebuild it where it is?
Yeah,
You
why are you
can't.
building it? Why do you have to build it? Why
Why
are
do
you
you
moving
gotta
it and
take
building
it
it in the
off?
backyard?
I
You
mean,
can't do anything with it. You can't even put a door in it or a window in it
You
or
can-
anything else
Why?
right now. And it's
But if it
at
was
zero
approved-
setback from her client, and it's right at the front, and it's also on
Is it a
zero
dirt
from the
floor
front
right
line.
now?
It's at zero from the front.
Is it a dirt floor right now?
No, it's a broken up concrete.
So
There's no
you
foundation.
couldn't sister up to what's existing and just
No.
rebuild what's there? I
It's
mean, I
not
see
hooked up
it.
to the foundation. It's just sitting on this board. That's what the engineer's report said. You cannot do anything to it. We fought that battle at the HDC to move it back and try to get it out of the setback. Moving it back gives a little bit more space and air between the front lot and the house
Because then
that's
you
already
wouldn't
there.
need our approval if you just,
We can't do it where it is, because we have to rip it all apart, and there's nothing left. And it's still at zero from Sarah's client's house.
and you
I
want to
don't
move
wanna
it
build-
further
But
away.
people build in town all the time, Linda, and rebuild where they're at. Like, they just, this is the first one I've ever heard where you're gonna move a structure into the middle of the yard, build it there, and then move it back.
We have no choice. It's at zero setback at the moment.
I don't understand.
And there's no way to truss it, according to the engineer, and we've all been over, and then we took the ivy off, it was a problem. But there is nothing we can do where it sits on that structure. There's no foundation. If we try to pick it up, it's falling
She's not
apart.
gonna let you talk. What?
And it is actually more dangerous where it is.
All right, now Michael's gonna talk.
Question. Are you worried about the side that's at zero setback? In
Yep.
terms of fixing it?
That's one thing, yes, and the fact that it's unstable.
Have you ever talked to the neighbor about maybe, or delivered a pie or anything?
A what?
Well,
She's also at a different elevation than we are. We're higher.
well.
She's got her patio back there.
There is a statute that allows.
It doesn't really matter, it's too low.
Yeah.
Yeah.
But are you saying that I should leave it in the setback?
I'm just curious, as, you know, you could go up exactly where it is, and
There's nothing to go up
it's
on,
withstood 100-mile-an-hour winds for,
because it was covered with, did I give you the
Ivy.
picture of the
Yep,
ivy?
yep, yep.
I mean, there was no structure, it was just all ivy. But no,
so, I haven't inspected it, I saw the pictures.
All right, John's gonna go, so that's okay. Yeah, go, go. All right, so we need to move on, I think, because we're just going in circles here. So the addendum does say, the use will remain as a garage with a studio added. So she's
I'm not
asking,
gonna play that game with you guys, I gave you everything I had.
I know, but you could have put like the sections. So.
Is there somebody else that needs to talk that's, are you?
Oh, yeah, he's going to talk. Sorry about that. Go ahead. I'm sorry. I got caught up in the.
Hi there, Kevin Toth, 128 Main Street. I'll keep this short because I am the one who wrote this letter, so most of it's all detailed in there, but just really, first and foremost, all of this is just completely self-inflicted. I mean, the way it's been divided as of now, I mean, all these issues that they bring up are completely self-inflicted. The property was fine as it was. They split it up like this, and now they have to move the house. You know, in terms of you know, height versus elevation, it is going up because it is going up the grade. So when they move it back, it is going up. So that is a pretty significant change. But let's see what I have here. One thing I would love to request is just a copy of the inspection report. I think it would be fair for everyone to be able to see that, you know, and see what it says in there. Oh, is it in there?
Of the structure?
I think we just got that today.
Just got it?
Yeah.
But yeah, I'll leave it at that. Well, actually, my one last point is, and it's hard in this packet, but is what have they done to maintain the home? Since they purchased the property, that shed has fallen into complete disrepair. There's a lot, I mean, you can see photos of it from when they bought it and see the inside of the photos that were taken by them. I mean, there's a lot that could still be done to keep this old historic salt box style garage that was here when Nantucket first had cars. I mean, it's completely exploitative and wrong, this you know, application. It's kind of a no-brainer, but anyways, most of it's detailed in this report, so I really appreciate your time. Thank you.
Thank you.
Madam Chair, one more comment here. We're talking about the setback. We're talking about, is it substantially more detrimental to move it back so there's more room and get it as far as the HCC would let us away from the setback? That's pretty much cut and dry. Not the driveway width, not the fact that there's another house going which is conforming, or another little shed thing going up there. None of that is relevant.
Was there any discussion at the HDC about constructive demolition?
No, and we didn't do it. We haven't owned it that long. All we did was take the ivy off it, and what you see is exactly what was left.
Those holes in the roof came when the ivy came off? I mean.
Yes, and I have pictures of the entire thing from the beginning to when we took the ivy off, and all of those holes and all of that decrepitness was on that structure when we took the ivy off, because the ivy was the only thing really holding it together, particularly the ridge back. And it's not changing the salt box character. The only thing the HDC has jurisdiction over is the visibility from the street. And the only visibility from the publicly traveled way is up that 10-foot driveway. And they asked us to leave the carriage doors or garage doors, so that's visible from the street. That's all they had jurisdiction over as far as the design of the structure, for the most part.
Okay.
But we agreed to keep it in the same volume.
Okay. Okay.
We could have appealed it, and we didn't.
Okay. Sarah, looks like she has something to say, and then I'd like to close the public hearing if we can and get to gas tax.
Thank you, Madam Chair. I just had one comment that I didn't make before. I mean, your standard here is substantially more detrimental to the neighborhood. And I would have to say that changing a use from garage to a garage studio where people can put billiard tables and
We're not giving
whatever
them the
you said
okay
you were
to
going
that,
to
are
do,
we?
2 feet away from the property line is substantially more detrimental than a neighborhood, than a garage. It just is. There's going to be noise and people and coming and going, and it just is a significant increase. So I would say, if you're going to approve this, keep the use as a garage.
Okay.
There's just, you should really look at this whole thing. It's kind of egregious, but it's kind of not in your purview, but you should look at it.
Right, so the question before us that we started out talking about this limited request about retaining the pre-existing non-conforming location has morphed into a request for a use change and a demolition. We've already said we don't, so does anyone in the audience have anything else to say at this point before we close the public hearing? Anyone on Zoom for this one?
I have just one comment.
Quickly.
If your car is not in the garage, and how many of us drive, I've never parked a car in my garage, it just sits in front of it. If your car sits in front of the yard, in the driveway, are you telling me we can't step foot in that garage?
No, Linda, but it doesn't matter. It's there, if you need a permit for a change of use, you need a permit for a change of use.
Well, I have to get to the building permit for a change of use too, so. But it's
What?
not, we're not asking for a humongous thing in there, we're just asking to be able to, kids can go in the French doors, which face the yard, and move on. If they want to play a ping pong in there, whatever.
Yeah, but
If
it
there are
doesn't-
noise
okay.
ordinances and everything else, but we tried to get it away from her client. I mean, it was just, they would not let us do it, but they understood what it was at the HTC meeting, and that's the end of it.
Linda, okay, thank you.
Which is just to say that the garage is being requested to move back because since it was built to go with the original structure that fronts Main Street, it is very, very close to that structure. And the plan now is to create this new dwelling. So they're moving it because they're changing the use and changing the proximity. It's not just inevitable, we need to do this. So I just wanted to mention that. Thanks.
Okay,
Madam Chair, could I?
yep.
Where's the letter that he referenced? Is that in our
That he
packet?
wrote, his letter was later
Oh, okay.
on email, and
And I'm just seeing it now.
okay, well, I gave my copy to Sarah, but,
And then she just gave it to me.
okay. All right, well, I guess I'll find it in my email and reprint it, but do you want to look at it, Jim?
Yeah.
A lot of it's stuff that came up at the HTC, which is irrelevant.
I should get it in my email here, Billy.
You've been listening to it for 2 years.
All right, so there's been so the garage now is on the 0, and it's going to be moved back to the same area. But how far off the?
12 feet back. And I think the
So
front
you're,
right corner-
You're not talking about the final move.
No, it's going over there and coming back, because we have to reconstruct everything underneath it.
But so you have to keep it in the location where it's close to the main house, the original house.
No, that's why it's moving back 12 feet. They approved us to move back 12 feet.
Then
So they
why
could-
are you,
Because it's still inside the 5-foot side yard setback on the east side. That's why I'm
so it's
here.
not going back to where it is now?
No, I didn't say it was. I never said that.
That's
That's
what I heard. You
thought,
kept saying
too.
you were moving it back, moving it back.
That was my
said it every
confusion in the
time.
beginning. That was what I wasn't
We're moving
catching.
it back 12 feet and out to 2.7 at one corner and 2 at the other corner. That's what we were
So why
going to do.
can't, so,
They won't let us move any further away from the side yard because they want to still see the doors, though they're reconstructed and nicer doors. They want to still see the garage doors at the back, going up the driveway to the garage.
oh my gosh, Linda, you made it so much more complicated than it
No,
had to
it was
be.
complicated for 2 years now.
Say that the HTC is making you move it back.
No, we asked to move it back further. So it was away from her client and it was back, we're sort of in the same direction. They wouldn't let us move it any further back, so the agreement was to allow
So
it to
you're
move
just
back
picking
12
it up,
feet.
you're gonna put a foundation in or whatever you're doing. Then you're
Slab.
gonna move the thing onto it 12 feet from where it is now, still in the 2.5 feet into the setback.
No, it's going out of the setback, if it will make it out of the setback, have all the stuff done to it, or it's gonna demolish itself. That's what the engineer's saying. We have nothing to brace it on. There's nothing to brace.
I'm not gonna worry about that.
Where we're moving it out of the setback, which is why I'm here, because they want us to put it back in the setback. No matter what the building is, it's going back at 2.7 and 2 instead of 0.
So
But
we're only
12 feet
approving.
further back.
We're approving the we're approving the, that
Lateral.
the 0 to 2.5 remaining in the setback.
And 2 at the back, I think. 2 feet is the closest point. It's not, yeah, to the setback, eastern setback,
On the side.
yeah. And then back 12 feet, because it's moving laterally in that 5-foot required setback. It's going back a lot, down the line.
I missed that part, sorry. That was my confusion earlier, sorry. But Madam Chair, it looks like the structure shape is similar, but not exactly the same, because you did a shed dormer for the 2 French
the
doors to
backside.
come outside.
Yeah, but otherwise, the ridge is the same height, the dimensions are the same, the pitch is the same.
And would you be willing to leave the use as a garage if we approved your, no?
It's only a 21-foot high house, and
Well, I think if you're asking us to change the use is going to be, in my opinion, the change to a studio is going to increase the intensity of the use.
But you can still
And
have
you're
the French
asking us
doors.
to do it in a bubble of not having, you know, the showing what the rest of the lot is going to look like. So personally, I'm going to be against changing the use. Because we don't have, because we're making a decision without all, I feel like without all the information. The
Well, then
move of the
continue it. I don't know
garage
what else
and
to
the
give you.
setback, I don't need to see all the other stuff, but I think when you're talking about use of a lot in general, the other structures or uses on the lot come into play with making that determination.
we figured out what we were doing with the rest of the lot after this was filed. If you want to continue it, I'll give you what we have going through the HDC at the moment, but it's irrelevant. But I can give it to you. But it has nothing to do with the garage setback or substantial.
Right, but it does have to
detrimental.
do with the use, I think. Does anyone else agree with me?
But it
or-
doesn't change the design. You
No.
wouldn't have to change the design of this. You could still have your French doors and it
For
could
what? I mean, I
Maybe you get out of
grew
your
up in a
car and
house,
you
we
wanna
put our
go-
pool table out there and a ping pong table in the garage because the car was in the driveway. I mean, so you're telling me we can't enter that garage except to put a car in it?
No.
Nobody's garage is like, I have never parked in my garage.
Okay,
I got so
well, we're
much
getting
stuff
off
in it.
track, and it's
Well, I think we're out of
4:20, and
control.
so we need to move on. So
If you want more
guess I
information-
guess I would like to see a motion to continue for more information.
What information?
Can we get permission to go on site?
Yeah,
I
a
can-
site
I can
visit.
take you guys up there.
after we get the overall plan of the other structures on the
Yeah, I just
newly
feel like
created
we've only
lot.
got one part of this.
Well, I object to that. I'll let you have it. But you have no rights over anything else on
Well, you're
that
asking us
property.
about the
Well, it
change of use,
impacts-
and that how
Yeah.
can we, if we don't know what else is going on the lot,
We need it to make sense.
That's not why I'm here.
you're not asking for a change of use. You
I'm
just
asking- Yes,
said you're asking for
but it
change
do-
of use.
what does that have to do with a conforming house and a conforming shed? I think we've got to be careful about tripping too far off why I'm here. I'm here because the HCC forced us in here. That's why. That's it. If we could have moved it out
No,
of
you
the
would need a
5-foot,
special permit, as Sarah
if I could
pointed
have
out.
moved it out of
keep
the
it in the
5-foot
setback.
setback, I would not be here.
No. Because it's a pre-existing non-conforming
Okay?
use, correct, you said, right, Sarah? That she would require, a change of use would require a special permit.
There is some
And when-
basis for that.
and when we're
except that the
looking at
garage is not
use-
a pre-existing non-conforming use, it's a structural issue. It's a structure that's non-conforming, not the use. The garage use is allowed as a matter of right. As you said earlier, so is a studio. The fact that it's in the setback, it's an ancillary structure. There is some basis for having a special permit specifically say you can add the studio to the garage. That's longstanding.
So if they left it as a garage and built out the whole property and came back and wanted to turn it into a studio, they would have to come back in front of us, correct?
Didn't we just do that on
Okay.
Academy? We just did that on Academy Lane.
Right.
Yep.
So
That's not a conforming situation at all. I got a conforming lot.
you're not conforming by being in the setback, though.
That's it. The rest is a 5,000 square foot lot.
Right, no, I realize that, but I'm saying the use of this structure has something to do with this application, not just,
This is just one of those instances where, like, it's really hard to make a decision when we don't have all of the information. And so
What is all the information you still
What
want?
else is
What else
going
is
on
being
the
applied
lot?
for?
Okay, that's beyond the scope of what you have, but
Is
I'll give it
that,
to you.
is that correct?
But it,
Yeah,
but
I'll
it,
give it to
No,
you.
I'm not asking, is that, Billy, is that correct?
Can I just, yeah, I agree with you 100%. But the abutter, I've never seen this before, they wanted to keep the garage where it is, even though it's 0 setback. So why not just leave it there?
We cannot leave it there
Because-
and fix the structure. It cannot stay where it is.
Well,
It's
because
also
if
on
you made
zero
a deal with
setbacks from the
Sarah's
front house.
client that you could do that, you had whatever
but
structural
they have the right
things.
to ask
We're not doing
to
that.
move it. We can just
So you
deny
want to
it.
move it back for,
To get it away
layout.
from the other
right,
house,
we-
yeah.
Madam Chair, if I
It's-
may, I think this should be
This is nuts.
continued. I
Yeah.
glossed over a few things in here. I mean, I didn't pick up on the use change. Every plan I look at that says garage to garage. So I think we need to suss out the full spectrum of the
intent.
request.
Yeah, and I really feel like this was, I'm just going to say this was a waste of time. Like, I'm kind of annoyed right now because it's 4:20. We are not going to get, like, I think this was a waste of time because we didn't have all the information. This is a very simple
I
request.
didn't know I had to give you the rest of it because it's not in your scope of,
But we'll
Yeah,
just
but
ask
Linda, you
for it.
kind of hid stuff in there. Like, let's be, like,
let's just
come on,
ask
just
for it
be.
and
I don't hide anything, and I object to that comment. I do not hide anything in an addendum. I gave you
Okay,
everything I
well-
had. So I really object to that.
It just doesn't
let's just
have,
make a
it
motion
doesn't
to continue
have
with
the
more
other
information.
sections marked. We didn't advertise for it. Staff didn't realize you
You
were
did
asking
put it
for
in.
it. Okay. Well, let's continue to August 15th. Sarah has something to say.
Can I
August
waste
15th?
one more minute
Yep,
of your
sure.
time? I just wanted to mention that I believe that the reason that they don't want to keep the garage where it is now is because it's impeding the development of the other houses that they're trying to put back there. They
Actually, we'd
need
rather have it
the
zero.
garage to move to do the development.
Yeah, that makes sense. I mean, that, when you look at, the
It does
as-built.
not. Actually, leaving it at zero doesn't, it actually impedes the other house moving it, but we're moving. It does not impede the other direction at all. There's
Okay, so
no-
let's
there's
talk
nothing.
about, like, so then if we could see that, like, maybe that would help. So
I think
if
we can make
someone
a
makes
fair decision, and I would like to make a motion to continue until August 15th and get the overall intent of the lot and where other structures are going, so we can make an educated decision. I don't think that's hurts you in any way, and I think if it was just a matter of the garage staying a garage and being moved, we would have been out of here 20 minutes ago. But there are more layers, and I would like to make a motion to continue with more information, also known as all the other structures intended to go on this piece of property.
Okay.
And
the
do you have
attorney-
to
I don't know if
renotice?
my
I think that's
lawyer will let me
reasonable.
do that, but I'll do it for you.
Thank
If
you.
somebody wants to go take a view, everybody's got my cell phone. I can take you up there.
Okay,
I'll second Alyssa's motion.
okay. 1, 2, 3, 4, 5. Okay, it's the 5 of us, so all of us in favor, say aye.
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 Jim?
Okay.
This one's 5 minutes.
You're in,
I've got a
Brescher's out.
Concom meeting in the same room.
I was going to suggest this last one is a very minor
5
modification.
minutes.
Okay, let's do it. Let's
to
get
a
it.
I already
prior
know I'm gonna approve it.
VR pool special permit. Let's try to just
All
get
right,
through this.
Linda, you've got the.
We got a
floor.
pool, we got the same conditions, we moved it slightly because, and we made it reduce the size of it, because we're not doing a gunite pool anymore at 250,000, we are doing a $60,000 fiberglass
Oh,
pool.
you know, what? Hold on one second. This is the file number 22-24, 51 Washington Avenue and 281 Madaket Road. Sorry, I just
Yeah,
want to.
and so we moved it slightly, we reduced the size of it, which actually moved it, and that's it. All the same conditions still apply. Actually, it's going to disturb the exterior vegetation less because they bring it in on a crane and put it over the top of the vegetation. So it's going to require a whole lot less of stuff going on I Street. So that's it. Same conditions, same everything, just a new site plan. So basically, it's validating a new site plan and reducing the size of the pool.
Okay. Does anyone have any questions for Linda on this modification request?
I was going to add, if you look at page 270, that's the exact same site plan that we signed on the decision. The old pool is in black, the new pool is in blue. You
Okay.
can see it's a slight shift to the west, I believe.
Yeah.
Okay. So the findings, if we agree with this reduction in the pool size and location, the finding would be that the modifications to the pool size and relocation on the lot are in harmony with the general purpose and intent of the zoning bylaw. Oh, sorry, there's no one in the audience to speak on this one, so, and there's no one on Zoom, correct? Okay. So that was the first, well, I mean, not to speak.
All right, I got to go home and change because I
Okay.
have to run the comedy
That the-
festival in an hour.
Okay, well, that the proposal has met standards as stated in the bylaw for the following reasons. This is the comedy festival right
Yes,
now.
it is.
The combined lots contain 34,400 square feet of area in excess of the minimum required 20,000 square feet. And the pool and associated pool equipment will be sited in excess of 20 feet from any lot line. The conditions were all work be done in substantial conformity with the plan approved in conjunction with Certificate of Appropriateness 2024-06-1066 duly issued by the HDC. The location of the pool and existing and proposed vegetative screening maintained and installed substantially as shown on the site plan for pool installation prepared for Leslie Johnson, prepared by Nantucket Engineering and Survey PC dated June 7th, 2024, reduced copy of which is attached hereto as Exhibit A, and all previous conditions of the original decision shall remain in full force and effect.
So in essence, the exhibit.
I would
A
like to make a
change,
motion to approve.
HCC change, that's the two things.
Okay. So Elisa's made the motion, Jim has seconded. All those in favor of approving this modification?
Aye.
Aye. Okay, that passes. All right, Linda, we will see you in August.
But call me if somebody wants to go up there, I can give you the whole list.
Perfect.
And wear heavy boots.
Maybe get us the layout early, sooner than later.
Yeah.
As I say, we're still going through.
All right, let's stop talking about it, please. Linda, we're done. We can't talk about it anymore. Have fun at the Comedy Fest. Okay, you run it? Okay. Okay, so, I guess that's it.
That's it. We skipped over election of officers. I
know.
figured we got enough other things
do
to
it
do. We'll
later.
get to that when we get to it, hopefully next month. And then
Okay.
just our next meeting is next Wednesday, July 17th.
Yes, please.
Second.
Okay, all those in favor of adjourning?
Aye.
Okay.
Thank you.
Yeah.
Good job.
Thank you.
Don't forget your phone.
I won't. My children were